Good afternoon and welcome to a session of the Appellate Division First Department. I will begin with a call of the calendar, so counsel, please pay attention for the name of your case. People versus Angel Rodriguez. Appellant?
Yes, Allison Haupt on behalf of Mr. Rodriguez.
Good afternoon. You have 5 and 1. Respondent?
Samuel Goldfein on behalf of the people, Your Honor.
Good afternoon. You have been granted 5.
Thank you.
Lara versus Tuck It Away. Appellant?
Yes, Greg Friedman for appellant.
You've been granted 3 and 1. Good afternoon. Respondent?
Good afternoon, Donna Margie on behalf of respondent.
Good afternoon. You've been granted 3 minutes.
Thank you, Your Honor.
B. Daniel versus Selena T is submitted. North Staffing versus 622 3rd Avenue. Appellant? Appellant, if you're speaking, please unmute your mic. Okay, hopefully you will be back with us when the case is called. Respondents Counsel?
Good afternoon, Bruce Bieber for the respondent, North Staffing Group, LLC.
Good afternoon. You've been granted 4 minutes. Paulino versus Braun.
Good afternoon, Your Honors. Joshua Gropper for the appellant.
Good afternoon. You've been granted 4 and 1. Respondent.
Good afternoon, Irina Kravchenko for the respondent.
Good afternoon. You've been granted 4 minutes. People versus Sheldon Parker. Appellant.
Good afternoon, Megan Bird for Appellate Sheldon Parker.
Good afternoon. You've been granted 5 and 1. Appellant.
Your Honor, this is Susan Kleiner for respondent.
Good afternoon. You've been granted 5 minutes.
Thank you.
Gomez versus Vornado, 640 5th Avenue. Appellant.
Yes, Lester Channon for Curtis Partition.
Good afternoon. You've been granted 4 and 1. Respondent.
Good afternoon. Dominic Zafante for all the respondents. Vornado.
Good afternoon. You've been granted 4 minutes. Marino versus Wells Fargo Bank, submitted at the initial calendar call. People versus Ryan Williams is submitted. Wenzel versus All City. Appellant.
Good afternoon, Your Honors. Thomas Shreley for the appellant, 217 East 88th and 212 234th East 89th LLC.
Good afternoon. You've been granted 4 and 1. Respondent.
Good afternoon, Your Honor. This is Melissa Lenowitz for the plaintiff respondent, Ilona Wenzel.
You've been granted 4 minutes. The next case is going to be the first case called out of turn. Justice Schulman has recused himself and Justice Kern has been vouched in. Salvatore versus 55 Residents Corp. Plaintiffs, Appellant's Counsel. Appellant's Counsel, if you're speaking, please unmute.
Trying.
Okay, we heard you. But if you're talking now, you went silent again. Well, at least we know you're there. And try to get that mic to work since you're the first case called and you have been granted 4 and 1. Respondent.
Good afternoon, Your Honor. Chad Chokwas for respondents.
Good afternoon, sir. You've been granted 4 minutes.
Thank you.
People versus Danielle Santiago is submitted. Sorge versus Sharp Management. Appellant.
Jason Steinberg, Burns and Harris. Good afternoon.
Good afternoon. You've been granted 4 minutes. Respondent.
Good afternoon. Sage Subik for respondents.
You've been granted 3 minutes.
Thank you.
Lopez versus 1355 Morris Avenue. Appellant.
Beth Rogoff Gibbons of Tascone and Klopko.
You've been granted 4 and 1, assuming we have a respondent. Respondent's Counsel, Mr. Schwartzberg, are you on the call?
Good day. Yes, I am here for respondent.
Wonderful. You have been granted 4 minutes.
Thank
and
you.
Lamin versus Lamin Appellant's counsel.
Good afternoon, Your Honors. I'm Matthew Keston for the appellant.
Very well, you've been granted 4-1, and respondent's counsel.
Good afternoon, Your Honors. Matthew Ehrlich for the respondent.
Good afternoon. Okay, first case on the calendar out of order. Salvatore versus 55 Residence Court. Before we begin, I need everyone to turn off their mics because I'm getting feedback from somebody. That sounds much better. Okay, Mr. Harwood, you are up and you have 4 minutes.
Can you hear me, Your Honor?
Yes, we can. Proceed.
Okay. So this is an appeal of a denial of a motion to renew amendment to include a cause of action for intentional infliction of emotional distress. And what happened here is there was a report of an engineer, Rand Engineering, dated April 10, 2018. And this report was not provided until June 3, 2019. So there was a 14-month delay in providing it. And we obtained it by doing a non-party subpoena of Rand Engineering. And basically during this 14-month period, there was a motion practice during which we did not have the report. The shareholder had moved to have a laundry vent removed and to amend his complaint to include a cause of action for intentional infliction of emotional distress. And in September of 2018, counsel for the defendant represented that there was no evidence that toxic fumes from the laundry vent were emitting into his apartment. And at the time that that representation was made, they had the Rand report, which not only confirmed that the vent was illegal, but had a photograph attached to it showing the fumes going into Mr. Salvatore's apartment. Basically, the court denied the injunction request, including because of the assertion that there was no evidence that there were fumes going in the apartment, and also denied the request for amendment. So what happened on or about 3 or 4 months later, we finally got a copy of this report, and we deposed the engineer in July of 2019. Didn't get the report until June of 2019. Basically, the defendant claims that they never saw this report, that it took over a year for them to find it in their files. But the engineer said we sent it to the defendant, in April of 2018. And their claim on appeal that they never found this report is further belied by a follow-up email.
Okay, I need you to wrap it up because you're out of time.
Okay, dated May 2nd, which the engineer says want us to revise the report. He suggests that the report provided additional evidence to add the cause of action for intentional infliction of emotional distress. And
okay, you'll have a minute on rebuttal to tell us a little bit about that, since it took you a bit to get there. Okay, respondent.
May it please the court, Your Honor, Chad Chokwas for respondents. We'll rely primarily on our briefs, but my client and I, since I was involved with this discovery process, we do want to emphasize one thing. The argument that we withheld a report, one out of several that were produced, is just not true. My client, and this is in the record, it's in the brief, Justice Getz covered it in his decision. They did a search in response to a demand. They didn't have this report. Even after the report was produced by a non-party, even after it was produced, we went back again to check to see if they had this report. They didn't have it. There's no emails in the record that this report was an attachment to. There's nothing in the record that says this report was provided. And if we had it, we would have produced it. The first I got it.
So here's my question, though. I
Sure.
mean, because I found it very confusing. How did anybody know about the report to subpoena it if nobody knew about the report? What did we know in order to provoke a non-party subpoena? There must have been something.
That's correct. And the answer is that we produced a number of documents that we received from RAND, including emails, including other reports. And Justice Getz discussed this in his decision, timely in response to a demand. So obviously, everybody was aware that there was a proposal. We knew that too. The work was eventually done. But this was a single report that only RAND had. And again, this was in response to a blanket subpoena for all the documents that this engineer had regarding this project and this issue.
So the subpoena didn't identify this particular report?
No, not at all. It was just a blanket document subpoena for everything they had. And again, we had disclosed, and it was about 300 pages of documents, many of which included other reports and correspondence that we had with RAND. So this was
I'm sorry to interrupt you, but it's a short time for oral argument. And RAND was your contractor, your expert. Who are they?
I apologize. It was our outside engineer, one of a couple engineers that we had hired in response to plaintiff's complaint to figure out what the code requirements were for this laundry vent. And there was another issue, a drain outside the building as well. So again, and Justice Getz, I want to point something out too. This is an abuse of discretion standard. Plaintiffs never argued abuse of discretion in their brief, which itself I believe is dispositive. But Justice Getz, who's had this case for, I believe, about 6 years, was fully aware of all these issues. There have been a number of discovery disputes during this case, most of which have been resolved in our favor. But he considered all this in his, report.
Yeah.
There was one that was not, that's true, but he considered all of this in his report. And again, there's no basis for an abuse of discretion finding, and plaintiff didn't even argue in their brief anywhere that there was an abuse of discretion here. So again, the record about when this was disclosed and why, it's in our brief. It wasn't withheld from anybody. I received the report the same time that Mr. Harwood received it in response to the subpoena, and it's that simple. And the other thing I'll point out is plaintiff waited. He filed a note of issue, and then he waited another 5 or 7 months, I believe, before he raised this. There were at least 2 discovery conferences before Justice Getz after this report was disclosed, and it just wasn't timely. So thank you. We'll rest on our brief otherwise, and thank you for your time.
Thank you so much. Okay, Mr. Harwood, you have 1 minute and unmute. Unmute. You're still muted. Can't hear you now.
Okay, so the email was May 2nd. It said, "You've got our report. Do you want it revised?" There's no question they had it. They delayed until after the oral argument on the injunction to even give us the papers that they say they gave in January. So why did they delay 8 or 9 months to give those? We did do these because we knew that we weren't getting a complete production. Then they waited another 4 months to give us that. And we did file and depose in July the engineer. Then comes the note of issue. Then they finally removed the laundry event on October 9th. And a week later begins the summary judgment practice. So if I'm sorry, my mute is not working, but I'm trying to do it by phone. And
It's okay, we can hear you.
okay, I'm on Nor later on. The clerk
Okay,
said to tell you that.
very good. All right, we will
Okay.
talk with you later. Thank you so much.
Thank you, Your Honors.
Thank you. If counsel on People v. Angel Rodriguez will wait one moment while I get Judge Schulman back. Thank you, Judge Kern. Give us a moment. Judge Schulman, if you can speak so I can pin you.
Right, I'm here. Thank you.
Okay. All right. Counsel for appellant on People v. Rodriguez. I will hear you now.
Thank you. The jury convicted Mr. Rodriguez of gun possession, even though surveillance video showed multiple frames where he had empty hands, and despite the incredible bias that infected the prosecution's case. All these problems raised a reasonable doubt which warrant reversal in the as against the weight of the evidence. I want to start with what I think is the most compelling justification for reversal in this case, and that's the surveillance video. You have a copy of that surveillance video. It's Exhibit 1. And I encourage you to watch it specifically at a slow 0.5 or even 0.25 speed, because then you can see multiple frames per second at 16:20:55 and 16:20:56 when Mr. Rodriguez is coming back to the vehicle, when other witnesses were claiming that he had a gun in his hands. You can see in multiple frames that his hands appear empty. Respondent wants to ignore the weight.
Is the film clear or is the quality of the film grainy?
So of course it's a grainy video. It's inside of a store looking, so shadows are everywhere. You can see, for example, there are shadows all over Mr. Rodriguez's shorts.
So
and clearly we know that those aren't objects.
Should we put more weight on a grainy video or the testimony of live witnesses?
Well, I think you should put a lot of weight on the video, because just because it's grainy, if there are frames where you see that his hands are empty, then that means that there wasn't an object there at the time. Shadowy doesn't. There's another frame.
Your video keeps on going in and out, so we are losing about every 6th or 7th word.
Oh gosh. Let me see if I can move my location to make this better.
I want to give you the benefit of the full argument.
Yes, thank you. I apologize. Is any of this better?
Yeah, go ahead. Keep trying. We're going to work with you.
Okay. A shadow video isn't going to show the absence of something. Just because it's shadowy, if you see in a frame that there's nothing there, then those shadows can't be objects. Then those shadows are not a gun. And so that in and of itself should
Counsel, this is Judge Owing, but there's testimony, evidence in the record that the other bystanders in the store reacted to something. They all sort of ran away from something. So that I know there's a shadow that you can't tell if it's a weapon or not, but you can get evidence where presented to the jury that people reacting, they're not running away from nothing. Something caused them to move quickly away from the window where they were all staring at this transpiring altercation.
Right, of course.
I mean, this is a weight issue, as Justice Manzanet said. I mean, the jury's going to be looking at all that. I mean, the video is grainy, but you have reaction from everybody else that's going on there.
Well, if you look at the video, what they're reacting to is the sound of gunfire. They're
Well,
clearly
yeah,
not
I would think so.
right. So we're not talking. The weight of the evidence issue isn't to say that there was no gunfire today. It's to say on that day. It's to say that there's not a reason to believe beyond a reasonable doubt that Mr. Rodriguez is the one who possessed the gun and that he's the one who
What do
caused
we
the
do with
gunfire.
the testimony, the eyewitness testimony of Murphy, who is quite familiar with guns and would not be the kind of witness that one would fear that seeing a gun is going to blind his ability to remember things. He was in Afghanistan, for God's sake. So seeing guns was like chewing gum, okay? So, and he not only said that it was your client, he said exactly what kind of gun he had because he had shot one, etc. What do we do with that testimony?
So Murphy, we have to remember that people view things based on their lived experiences. And somebody like Murphy with that kind of experience, spending so much time in Afghanistan, if you're going to hear a gunshot, he of all people is primed to then see a gun. And we have reason to doubt his perception. He didn't actually witness the gunshot. He was running away after he heard the sound. He was 50 feet away, hiding behind a large pillar, looking out for his friends to make sure that they were safe. And while all of that is going on in a matter of seconds, he's claiming two-dimensionally that he can see a gun. And so is it really that hard to imagine that based on his lived experiences, he hears the shot of gunfire and then he believes he sees a gun in a matter of seconds, especially when that surveillance video is showing at the same time an empty hand. And I know I keep on going back to this.
Can I just stop you there? Well, what you're saying, I guess it's plausible, but it's equally plausible that he testified he saw a gun because he saw a gun. It was corroborated, quite frankly, by the complainant who said he pulled a gun on me. People heard gunshots, so we know there was a gun there. I understand in your favor, the gun was never recovered, but there was evidence of a gunshot that occurred that was consistent with the complainant's explanation of where the gun was fired and how it was fired, that it was fired down and it hit something on the van. So I understand what you're saying. It's not implausible, but I have trouble understanding why that isn't just an issue of credibility that goes to the jury, that tips so much in favor of the defendant here that we would toss the verdict on weight of the evidence. I think that's what I'm personally having trouble with.
Well, I think the standard for weight of the evidence is if it wasn't unreasonable for there to be an acquittal in this case, that you should act as a 13th juror.
That's the first piece of it. And then the second piece is an evaluation about whether we're going to stand in as a 13th juror. And we mostly on credibility issues defer to the finder of fact. I mean, certainly it was circumstantial. Well, actually, I take it back. It really wasn't circumstantial. It was direct. People saw him with a gun in his hand, and the jury could either choose to believe that or not. I take that back. Right. I think that's a problem in this case. Can I ask a question? I know because I know I'm not letting you answer, but I'm more interested in the issue about whether we have a record on which we can rule on the circumstance regarding his clothing.
Right. So I believe that there is a record. There wouldn't be a suppression hearing in this case because they didn't actually seize the shirt. And so it's not like that was a hearing that should have happened. The question is whether the testimony regarding his refusal should have been allowed. And here it shouldn't have been allowed. The respondent is frankly admitting that this was not evidence of a crime. It wasn't the shirt that he was alleged to have been wearing at the time. It's not the shirt that you see on the surveillance video that was described. And they had no interest in testing it. They didn't test anything, frankly, in this case, which I do, on weight of the evidence, think is also a problem, that there was no gun residue testing.
Thank you. But they can't residue test an item they don't have. But you'll have time on rebuttal. Mr. Goldfein, you have 5 minutes.
Thank you, Your Honor. Good afternoon. May it please the court. Samuel Goldfein on behalf of the people. I'll try to be very brief. Just about the surveillance video and the people in the nail salon, you can watch the video, you can go through it slowly. The second that defendant turns around, the people in the store start panicking. It's not a gunshot. He's nowhere near where the bullet is found, which is right outside Aravallo's van. It's the moment he turns, the moment that if he had something in his hand, that object would be pointed towards the window. That's when the people in the store start to panic. As far as the shirt, defendant had no right to refuse that search. It's an almost irrelevant part of the people's case, except that the fact that he changed his shirt in and of itself is relevant and shows consciousness of guilt, as this court and the Court of Appeals have ruled several times. And if there are no further questions, I'll rest on my brief and ask that you affirm.
Colleagues, any questions? Okay, Ms. Howe, you have a minute on rebuttal.
Thank you. I would just argue, please watch that surveillance video closely. Obviously, in watching the exchange that's going on outside, but they don't run until clearly what is the sound of gunfire. Mr. Rodriguez is well off the screen at that point in time, and Ms. Lozada returns almost immediately. So you know that it's the gunfire they're reacting to and not seeing anything. In fact, Chopra, who has incredible bias affecting her testimony, but she admits that she's standing right there and does not see a gun in Mr. Rodriguez's hands. I want to touch upon the sentence here as well, should your honors not reverse as against the weight of the evidence. I would argue that the minimum sentence is most appropriate here. I don't want to pretend like Mr. Rodriguez hasn't made mistakes in his life. He's the first to admit that he has, but I do think that he's a product of his environment and his circumstances, the personal trauma that he faced, the influence from his peers, and certainly the prison system that's not built to raise a young 16-year-old boy into a man. But the benefit of a resentencing proceeding, which we have in this case, is that we get to actually see the person that he has become. And that person is a truly wonderful father, a model inmate, despite being in a maximum security prison, not a single disciplinary ticket, a mentor to younger inmates, and a calming presence in the psych ward where he's working as a porter. And so all of those attributes show the type of person that he is, the way that he's changed. And so isolation and retribution aren't necessary in this case. I think it's
what is your suggestion in terms of a reduction? Should we consider it?
To the minimum of 7 years. And the last point I'd like to make is just, it's impossible to not view his sentence in light of COVID-19. He has severe asthma, which the record reflects. He has lived every single day of this sentence.
Counsel, I've given you 3 minutes when I granted you 1. Thank you so much.
Thank you.
Got your brief. All right. Okay. Duval Lara versus Tuck It Away.
Good afternoon, Your Honors. Can you hear me?
Good afternoon. You have 3 minutes.
Okay. I guess you can. Thank you. I should be quick here. We have plaintiff's testimony describing the defect he fell on. We have photographs showing the defect he fell on. Obviously, we have our expert, and we even have defendant's own witness who testified the sidewalk was in disrepair and that he reported this condition and it would have been for safety reasons. So in short, we submitted admissible evidence that that this defect was non-trivial, and defendants in opposing the motion submitted no competing evidence of their own.
Well, this is Judge Shulman. In analyzing your supporting evidence, did the expert, Mr. Lowenstein, actually visit the sidewalk in question and take measurement to determine whether there was a vertical differential that would constitute a substantial defect, or did he simply rely on various photographs, some of them at least 2 years before the accident in question? So did he do something that would give your supporting evidence some teeth, so to speak, to get partial summary judgment on negligence?
Well, he did not personally visit the site. That, I admit, he relied on the photographs, which I think were enough. I think it's well settled that courts can decide whether a defect was or wasn't trivial based on photographs. We have defendants moving for summary judgment where they rely on that. And I think the reverse can be true here.
This is Judge Gish. Doesn't it depend on the photographs, though, on the nature and quality of the photographs? You'd concede that, right?
In some instances, I would say yes, but if you look at the photos here.
We're going to get there. Just right. I wanted that concession. It's true. Right. It depends on the nature and quality. So then let's look at the photographs here. Do the photographs here support any determination regarding the dimensions of the defect? They show something. I'm not going to deny that. but can you tell the depth of the defect?
From looking at the photos
from the
myself,
photographs,
I'm sorry.
from the photographs in this case. Yeah.
I think you're definitely correct. They show something. We all know that. There's a jagged triangular.
That's not good for you if they just show something. You're looking for summary judgment. You got to be showing something more than something, as Justice implying.
I agree that there is more. I was just echoing Judge Pitt's statement that there is certainly something. I think there's more than that. You can see. I'll point you to page 211 of the record. That's the one that plaintiff circled. It was blown up at page 329, which gives you a little better perspective on it, where you clearly see a large darkened area that takes up a significant part of the sidewalk. And then I think if you combine that with plaintiff's description of the defect, which
what would have been helpful would have been a photograph with a ruler in it.
I agree that would help.
So you can't leave things to can't you see that? I mean, that's what you're arguing.
Well,
can't you see that?
This is what I would point you to. Is this court's decision? I'm sure you're familiar with the Tropper versus Henry Street settlement. It was back from January of this year, where the facts are actually extremely similar. Plaintiff tripped on a sidewalk. He himself at a 50H estimated there was approximately a 3-inch height differential. There were photographs. I do not believe there was any expert evidence in that case.
Your client's measurements on this, you could bury a dog in, and we have no affidavit of any kind that says I measured it and this is what it measures. But you'll have time on rebuttal because we're over your time.
Thank you, Your Honor.
Counsel for respondent.
Good afternoon, Your Honors. I would like to point out that plaintiff's testimony, I mean, in appellant's brief, he is quantifying it. He said, although plaintiff testified that it was 3 feet wide, he was really indicating with his hands that it was actually 18 inches wide.
Well, let me stop you there. That's a pretty big hole, 18 inches. Okay, not 36 inches.
Well,
okay.
You don't know whether it was 36 inches, 18 inches, or 2 inches. I mean, you can't, this is
what else do we have? Let me stop you. What else do we have? We don't have anything in opposition. Your clients could have viewed the hole as well, and or somebody could have said, no, there's no defect there, or no, not that size, or no, we inspected it. It's at most 1/8 of an inch deep. We don't have that, which would certainly have made this case easier.
Well, Your Honor, in all honesty, the incident took place in 2016. So now in 2019, or 2021, whether it was in 2019 or 2020 when the motions for summary judgment were made, that would have been 4 years after the date of the alleged incident.
Your client doesn't investigate accidents when they find out about them?
Well, the witness that actually testified on behalf of respondent, if you look at his testimony, he testified that he was unfamiliar with the condition. He wasn't sure if it existed prior to plaintiff's incident. He wasn't sure exactly what the size.
You're not really answering my question. When did your client first find out that an accident occurred, or that there was a claim of an accident at the premises?
It was not until after the filing of this lawsuit.
So in 2019.
In 2000, and I believe this is a 2016 index number, but that was prior to us becoming counsel of record.
It has nothing to do with you being counsel. Okay.
Correct. However,
all right. So let's stop. Honestly, it would be a lot easier if you just answered my questions.
Sure.
Okay. So your client finds out about it, whether with you or not, in 2016. Nobody goes to look at the premises then?
The problem is that the person that would have knowledge about this alleged defect passed away. And the witness actually testified that it was Mr. Nick Spray Reagan who would have the most knowledge regarding this incident and whether or not there wasn't a defect, and he's no longer with us.
Okay, so now the question is, does the plaintiff's testimony regarding the dimensions of this site of the accident is that prima facie evidence of the dimensions of the hole?
No, it isn't, because the
Why
plaintiff
not?
was,
Why not? Go ahead, because, go ahead.
the plaintiff was unclear, which is evidenced by counsel's redescription of what plaintiff actually testified to. The expert that plaintiff retained did not go and inspect the alleged defect.
Did
There is
he
no,
rely on the plaintiff's measurements?
no, he relied on photographs that were provided by the plaintiff, some of which were not included in this record.
He did
And-
indicate, though, that the depth of the hole was 1/4 inch, right? Can you
It
say
was
that?
all, it was purely
Half inch?
speculation, because the
But
images
just let
that.
me ask your just let me ask the questions, honestly. It would really go a lot smoother, and maybe this is even a question that helps you, okay?
Of course.
Is the conclusion that the expert relied upon consistent with the plaintiff's description of the hole?
No.
Okay, thank you.
And that equals an issue of fact, right?
Correct.
Great. Anything else, counsel?
I apologize. I was just trying to answer the question.
That's
I
okay.
know, we
That's
understand.
okay.
We've all been on the other side of the bench.
That's quite all right. Thank
Yeah.
you so much.
Thank you, Your
Mr.
Honor.
Friedman, you have 1 minute.
Okay, thank you. I'll try to use it wisely. Just to clear something up, you can see at page 31 of the record, defendant answered in November 2016. It's a few months after the accident. So they certainly had all the time in the world to inspect this condition and submit some kind of competing evidence that there was not anything defective here. Our expert didn't say there was a 1/4 inch hole. He said, based on his estimates, it was at least 1/2 inch. And
Okay, but
plaintiff
my
estimated.
something different is that he wasn't relying on the plaintiff's recitation. He was relying on the pictures, right?
What he said was, I reviewed the photograph identified by plaintiff as a fair and accurate depiction of the sidewalk. So he did not outright say, I also reviewed the testimony. I think it's implied there, but I also think that plaintiff's testimony and the photos which plaintiff authenticated are enough. And again, I have to just
Well, he didn't say, the plaintiff didn't say 1/2 inch. He said at least 1/4, 3/4 of an inch.
No, I'm sorry. He did not. He estimated the depth at about 3 to 4 inches, the width at 1.5 feet.
I'm sorry, I had 3/4. That's even worse. That's even worse. It's not consistent with 1/2 inch. It's just not. So it's hard to understand what the expert was relying on, or that he was relying. If he was relying on the plaintiff's description, maybe it would be a different story, but he wasn't. He was relying on something else to make that measurement that he believes would have been exceeded a trivial defect. And maybe it does, but the question is, doesn't this now go to a jury or a finder of fact?
Again, I respectfully say no, and solely because the expert was clearly referring to the administrative code, which says anything 1/2 inch or more in depth is considered a substantial defect. And then in Tropper, what this court said.
We've got your brief. We are
Okay.
way over time. Thank you.
All right, thank you, Your Honors.
North Staffing
Thank you, Your
Group LLC, 622 3rd Avenue Company. Counsel for appellant.
Donald Harwood for appellant. So I'll try to be brief on this argument. This
You have
is
4
an
minutes.
appeal of a denial of partial summary judgment. The claim that we're moving on is the tenant's claim for delay in providing common bathrooms and flooring. And basically, there are 2 lease clauses that we say control. 1503 of the lease says that there will be no liability with respect to a landlord's change of passageways, entrances, and toilets, specifically mentioned. And it says this is because they're not a part of the demised premises.
Counsel, this is Judge Oing. Counsel, this is Judge Oing. Hello, this is Judge Oing. I have a quick question. So your basic argument is the demise premises is different from the build-out plan. We have 2 different situations here, correct?
I don't say that the diagram is accurate, and it does not include the demised premises.
Correct.
The-
So that the claim that they're looking to assert here has to do with something that's not part of the demised premises, right?
Exactly, and it's
Okay.
undisputed that the bathrooms are shared facilities. This isn't the only floor. And 1503, rather 2103 says, if there is a curtailment of services because of work in the common areas, then there will be no diminution or abatement. So if they have any remedy, their remedy would have been to and move to compel them, the landlord, to complete it, which they never did. So the bottom line is 2103 says no damages if there's work in the common areas. 1503 has liability to tenant for work in the common areas. And number 3, this obviously wasn't a part of the demised premises because it was a shared space and described as such in the lease. And with that, I will pass it over.
Thank you so much. Respondent?
Yes, good afternoon, Your Honors. Bruce Bieber for the respondent, North Staffing Group. I'm going to rely primarily on my brief, but I do want to get forth a couple of points. This is a matter of a tenant respondent who rented 20,000 square feet out of approximately 80% of the floor, $1 million a year in rent, Class A Midtown Manhattan building, and all they asked for were bathrooms. This is not, they weren't asking for the world, they wanted working bathrooms. And the landlord has taken the position that they don't have to provide any bathrooms, as long as you can have an elevator, that you can take an elevator to another floor in this building. We've done our job.
Well, what we're dealing with here is the delay of finishing the completion of the bathrooms on this floor, correct?
Correct.
They ultimately were completed. Am I right?
They were completed 8 months after the original finish date that was required to be completed, and 6 months after we moved in. So
okay.
for 2 months.
Could you address the specific provisions
yes.
that your adversary discussed with respect to the bathrooms being considered part of the common areas and not part of the demised premises?
Okay, there's 2 provisions which the appellant relies upon, 1503 and 2103. 1503 gave the landlord appellant the right to move, to relocate certain items, including, as counsel mentioned, the bathrooms. These bathrooms were not moved. These were not relocated. They did a gut renovation. Everything stayed where it was. So that provision is not the least bit relevant. And the case law is clear. You got to read a contract as written. Vermont Teddy Bear versus 538 Madison Realty. You can't just go ahead and create your own contractual terms.
Counsel, obviously this was space that when the lease contract was entered into, was space that had to be finished out, correct? It wasn't finished space. It needed to,
correct.
The construction had to be done, correct?
Correct.
And obviously there were no bathrooms on this floor at the time that the lease was entered into.
No,
right?
That's not correct, Your Honor. There were bathrooms. They
were gutted out, you're saying?
They were renovated. And again, we received a correspondence from the landlord saying saying the bathrooms will be ready in 10 days. We moved in on that. We got a writing which says they're going to be ready. We moved in based on that representation. We didn't have bathrooms for 6 more months. Okay, 20,000 square feet, over 100 employees taking the elevator every time they needed to use the restroom. And then the other provision.
Mr. Bieber, let me ask you a question. Could your client under the contract have refused to move in until the bathrooms were completed?
Well, we were getting threats of default, number one. Number two is our
Well, but leaving that aside, because that may have been correct or not, I'm asking you your understanding of a remedy under the lease.
Well, Your Honor, we had to move in for multiple reasons, that being one. The second being we were paying double rent, liquidated damages at our other premises. So we moved in based upon the representation by the appellant that they'll be ready in 10 days.
Understood. So you made your client made a business decision at that time.
Based upon the representation that they would be ready. Yes, Your Honor.
Okay.
Now the second provision, 2103, standard lease provision.
All right, I'm going to have you cover that during your rebuttal time because we've gone over, okay? I'll give you an extra minute on rebuttal to make sure you get it in.
Thank you.
All right, respondent. Appellant, I'm sorry. Oh, you know what? I'm confused. I'm going to have to give you that minute now. Go right ahead. I thought you were, I had the.
Mr. Harwood is
Go
on.
right ahead.
So just the other lease provision, which the appellant is responding says that, typical provision which allows the landlord to make required repairs, but it also requires them to do it, quote, use due diligence to complete the required repairs or other necessary work as quickly as possible so that tenants' inconvenience resulting therefrom, blah, 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 is minimized. So that's the appellant's obligation, contractual obligation. First of all, whether or not they did it with due diligence is clearly a question of fact. I don't see how it cannot be a question of fact, but I can answer that question of fact. It doesn't take 6 months to complete a small bathroom inside in a commercial building. They didn't do it because they ran out of money. They got sued by multiple contractors. Their construction manager was fired. His whole team was fired. They accused him of embezzlement. The appellant landlord ran out of money, got sued, mechanics liens, embezzlement, you name it, and that's why they didn't finish this project timely. And my client suffered the consequences.
Thank you so much.
Thank you.
Mr. Harwood, you have 1 minute.
Can you hear me?
Yes.
Okay. Number one, counsel keeps saying it took 6 months. What he's not saying is it was from September 28th. And in November, we had operational bathrooms. So it wasn't 6 months. Maybe soap dispensers weren't in until 6 months later.
Weren't they missing doors?
Pardon me, Your Honor?
Wasn't the bathroom missing doors?
Not for 6 months.
Okay, because a bathroom without a door is not a functional bathroom.
Correct.
I don't know about you, but not for me.
No, they were not missing doors for 6 months. But I think the important thing I want to say is it's a gut renovation. Obviously, walls were being changed. Walls had to be constructed in the bathroom. So that argument holds no water.
I'm sorry. Mr. Harwood, this is Justice Shulman. The provision you rely on, 21.03 of the lease, that gives you the right, that prevents the tenant from being awarded any diminution or abatement for curtailing services. You rely on that provision here. Now, if you go through that provision, does it actually include restrooms and corridor access as a service? Or does it refer to other types of services like elevator services? Or, does it expressly say that if you could prevent to give them a bathroom period, that you would be off the hook, so to speak, for any kind of abatement or diminution? Do you understand the question I'm posing, sir?
Yes, it basically says by reason of alterations.
No, I understand. Like by reason of alterations, certain services were curtailed,
Right.
Such as elevator service, heating, electricity, cleaning services. Does it say restrooms? Because there were no restrooms. It doesn't say restrooms.
No, 1503 does.
Right. So theoretically, an argument could be made that they might be entitled to an abatement going forward.
I would say that where you have alterations and repairs specifically described in 2103, and you have repairs and alterations described in 2103, that's what it's designed to cover.
Right.
And it talks about interruption, curtailment, suspension, work, or inconvenience. Clearly, that's what is being alleged in the second cause of action here.
Okay, thank
Okay.
you so much.
Thank you.
Paulino versus Braun. Counsel for appellant.
Good afternoon, Your Honors. May it please the court, Joshua Gropper for Mr. Paulino. This is a case that involves a recreational boat trip. Mr. Paulino was a guest invited by his employer, who was a buddy of the owner-operator of the boat, Mr. Braun. We believe that the underlying summary judgment decision completely missed the boat, applying the doctrine of assumption of risk. As the court is well aware, CPLR 1411, we prefer comparative negligence, not contributory negligence. There are a line of cases where the doctrine of assumption of risk is appropriate. Those cases tend to be where there are particular athletic or recreational activities, usually at designated athletic venues, with an unreasonably increased risk of harm. This case does not fall into that category at all. This is like a passenger in a car.
Our department has held that water activities and water recreational activities associated with water sports, et cetera, are part of the assumption of the risk doctrine.
You're absolutely correct, Your Honor. And the one case cited by the judge in the underlying decision, Jin Chung, 2017, I'm sorry, First Department 2016 case, dealt with a boating incident. Most of the cases, Judge, though, deal with zip lining, speed skating, horse racing, martial arts. The reason that Jin Chung was decided the way it was decided is Jin Chung involved a guy who was on an inner tube 60 feet behind a boat, videotaping another guy who was a water sports instructor who was 65 feet behind the boat. I mean, they were risk takers. They were out there doing what this doctrine was designed to deal with.
It's not sports, but one might say that standing up in a pair of socks on a wet boat when it is in choppy waters is likewise risky.
Well,
especially after having been warned by the driver to stay seated in the back.
If, Your Honor, if you accept defendant's testimony as gospel, I would agree with that. If you accept,
does your client really contest that they were all told to sit in the back?
Yes, my client contests that everyone was drinking beer, that he was up front, that they sped up the boat. He was never given a life preserver, and he went to get to the back to get to the life preserver.
Well, the life preserver really isn't at issue here because he didn't fall off the boat, right? So that's not at issue here. It's not part of what caused, and a life preserver certainly would not have prevented his fall here. So let's take that right out of the equation because for the fact pattern here, it's irrelevant. Can we agree on that?
Well, I don't know, Your Honor. I mean, if you're on a boat and you're feeling like you're in danger.
With the fact pattern we have here, tell me how a life preserver would have changed the injury or the fall.
You would if you were given safety instructions, if you were given a life preserver at the beginning of the trip, then if the boat does hit choppy waters, you're not afraid because you've got your life preserver. You're innocent.
Well, if he were afraid, as you just said, he should have kept himself seated.
He should have. And there's definitely comparative fault on his part. But there simply are too many allegations of negligence here against the defendant owner operator, between the beer, between the speed, between the lack of safety instructions. If you want
to just say that the driver was drinking beer? Yes, I don't recall seeing that.
The driver himself admitted that he may have partaken in the beer. And if he didn't drink at all,
I thought he said, I don't remember who
drank.
No,
the driver testified that he definitely may have had a drink. The friend testified that he didn't remember the driver drinking. Listen, this was a big joke to them, seeing this overweight Spanish guy up front in danger.
I hope that wasn't for my benefit,
No, it's not, Your
because
Honor.
whether he was Spanish or not is
No,
irrelevant.
Your Honor.
So counsel, this is Judge Owing. I just got a couple, I'm looking at your client's testimony. He testified that the water became, and looking at that first apartment case where we talk about the boating situation, right?
Yep.
Assumption of risk here. And the guy, like you said, was out there in a tube, you know, being pulled by the boat. Your client testified that the water became choppy, so he realized it was choppy. Your client also testified that his body was being lifted up and down as the boat was moving, and others began laughing at him.
Yeah.
So when you put those two together, doesn't that sign of, if you look at our first department precedent, indicate that there may be an assumption of risk there? I mean, if it's going up and down and his body was being lifted up and down, he's 350 pounds. Isn't that sort of an assumption of risk there at that point?
I understand your point, Your Honor. I respectfully disagree. I think it is distinguishable based on the inherent nature of the activities involved. He's merely a passenger, like a car passenger, and the First Department has ruled that if it's not a clear-cut case of the assumption of risk doctrine applying for sure.
It's more like a common sense situation
Okay,
here, right?
But if it's a close call, Your Honor, this department has ruled that it's a question for the jury. It's not a matter of law, whether or not the doctrine is applicable. And I think at the very least, Your Honor, you've got a close call here. I mean, from my perspective, I think it's a clear-cut, distinguishable case. But if you see it otherwise and it's a close call,
all right, we will hear you on rebuttal. Respondent, I'll hear you now. You have 4 minutes.
Good afternoon, Your Honor. May it please the court. Irina Kravchenko, I represent Mr. Brown on this appeal. It is Mr. Brown's contention that the Supreme Court correctly dismissed plaintiff's complaint based upon the assumption of risk doctrine. First of all, the doctrine itself is applicable pursuant to the plain language of the definition, which covers not only sporting but recreational activities. And as this bench has pointed out, the Chun decision demonstrated that it specifically was invoked in a boating case. And then actually in the Chung case, the court expressly rejected plaintiff's implication that this horseplay, it wasn't a valuable recreation, which is sort of a similar argument that plaintiff is making in this case.
Well, I don't quite frankly, the level of horseplay in Chung is clear that they were assuming risks that a normal, not even a water skier does, the way that they were horsing around. So while it's a good sight and shows that we would extend it to these type of activities too, given the proper facts, tell us why in these facts you think it's proper.
Your Honor, simply because it was a boating that was undertaken for recreational reasons, which is specifically defined by assumption of risk, and because it was undertaken in the Hudson River and the waters that are the venue proper for boating. This department, by the way, in the Chung case is not standing alone in applying assumption of risk to the boating cases. Every other department, second, third, and fourth, have stated that boating in general, without drawing any distinction, was specifically what was going on the boat, in essence, that invokes the assumption of risk. That's the type of activity that if you embark upon it, you assume certain risks associated with it.
But now, by the way, and this is a little bit of a side issue, but it does come up because the plaintiff claims he was inexperienced, but the risk of the boat going up and down in the water is appreciable by anybody, isn't it? It's what it appears to be.
Yes, Your Honor, that is precisely Mr. Brown's position. That is precisely what the Supreme Court held below in this case, that it is common knowledge. It has nothing to do with plaintiff's experience, and also it has nothing to do with plaintiff's physical attributes, to which counsel also alludes. Now,
this is Judge Owing, and he testified that his body got lifted from where he was sitting, too. It wasn't as if this was like a smooth, like a normal type of up and down. He testified that his body got lifted up off the where he was situated, right?
Precisely, Your Honor. Plaintiff, by his very testimony, made it very clear that he was very aware of what was going on, if the boat was rocking. And by making the decision to stand up under those circumstances, he assumed the risk that he will, in fact, fall. Now, that actually also applies with respect to all these other red herrings that plaintiff's counsel raised regarding the life vest, the instructions, the no shoes, even assuming they had anything to do with the fall, which they didn't. By being an adult male who decided to get on a boat with his friends, he assumed all of these conditions under the circumstances then existing, which includes all of these other additional risks that he undertook by embarking on that boat ride.
One other side issue here. You also alternatively argued that the boat was not operated in a negligent fashion, right? You put in a prima facie case on that.
Yes,
was that responded to in any way? What was the evidence of negligence here? Any effect on that?
Plaintiff's argument on this point were essentially similar as to the risk factors, the speeding, the unpreserved drinking, unsupported and unpreserved drinking claim, and these other issues. But the bottom line in with this argument as well is that, again, this wasn't a commercial boat taking out passengers on a ride. This was a bunch of friends, and Mr. Brown did not assume the duty to guarantee plaintiff's safety. And in addition to that, there's no evidence that anything he did or did not do actually contributed to the accident.
There's really no evidence that he was speeding. I mean, we have estimated rates of speed, but we don't know what the speed limit is.
Absolutely, Your Honor. And in addition to that, plaintiff never even said the boat was going too fast, nor did he say that it was going too fast and that's why it was moving up and down. He never even remotely blamed the occurrence on speeding. He repeatedly stated throughout, even though, by the way, he changed his testimony in many other respects, but he was firm on this issue. He said, I stood up because the boat was moving up and down in the waves and therefore I fell. In this case, summary judgment was granted based upon the assumption of risk, or alternatively, it can be granted because Mr. Brown was not negligent.
Thank you so much. Mr. Groper, you have 1 minute.
Thank you, Your Honors. It seems like many of you have your mind made up, but let me just point to a few.
Never assume anything from our questions.
I'll try not to. The defendant owner-operator was not a friend of Mr. Paulino's. Mr. Paulino was an employee of one of them. He was not a bunch of buddies out drinking on a boat.
What does that mean, though? I just don't, and this is not that I've made up my mind, but I just don't understand what difference that makes.
Well, it's a fact.
They weren't friends. They were certainly, it wasn't a commercial vessel. They were out recreationally. He was invited on for whatever reason.
Okay,
he was on. He was on. Okay.
Point taken, Your Honor. There was evidence. Thanks. There was evidence by the admission by the owner that the boat sped up. He did not know how fast the boat was going.
But sped up from what? Was it in violation? Let me finish.
Sorry.
Was it in violation of any laws regarding the speed limits for boats? Sped up only means it was faster than it was going before. That doesn't prove negligence.
Like a car, Your Honor, an operator of a boat has to operate his vehicle in a speed which is reasonable under the circumstances. If somebody's flipping and flopping on the top of the boat.
I don't disagree with, no. I don't disagree with your first proposition. The second proposition, I don't think necessarily flows. I don't disagree that you have to operate the boat in a non-negligent fashion. But where's the proof? Where's the issue of fact on that?
His own
assuming that assumption of the risk doesn't apply.
His own testimony is that the boat was going at a high rate of speed and that he was drinking. At the record at 240, he does not know how much he was drinking, but he was drinking.
But drinking in and of itself doesn't make the operation of the boat per se negligence.
No, but it's some evidence. Speeding.
It's evidence of what, though? Evidence
of negligence.
No, but you have to give me the standard that he violated. Was there a speed limit that he violated? Do you have an expert who said, oh, gee, he never should have been operating the boat under these conditions at this speed limit? There's something missing here, in my opinion.
If the plaintiff is flipping and flopping and the defendant can see that in the front of the boat, and he sees that he's operating at a high rate of speed under the influence of alcohol, he sees someone in danger.
You have conflated so many facts in that one scenario, but we have the facts, the record, and your argument.
Thank you, Your Honors.
Thank you, Your Honors.
People versus Sheldon Parker. Ms. Byrne, you have 5 minutes.
Good afternoon, Megan Byrne for Appellate Sheldon Parker. So there are two reasons that a new trial is warranted in Mr. Parker's case. Turning to the first one, it is that the court erroneously allowed the prosecutor to argue that Mr. Parker had committed a prior crime, despite there being no evidence that he did so.
Wait a minute. That's not what the judge did. The judge didn't say he stole from the car the day before. That's not what the judge did. And it was in response to the defense attorney's opening statement, wherein they took a good ruling for them and tried to go as far as they could with it.
Yeah, so the judge certainly didn't say themselves that Mr. Parker had committed the earlier break-in, but allowed the prosecutor to do so in summation at this kind of
response to the defense attorney opening on it and saying there will be zero evidence, et cetera, et cetera. And there was evidence. Well, there was at least possession of the credit cards. So
yeah, that's all there was. So I think if that were proper based on what the prosecutor or based on what the defense attorney said in opening, that should have been resolved then after the opening.
Counsel, this is Judge Oing. This is Judge Oing, counsel. And on top of that, the charge here was possession. It was criminal possession, had nothing to do with the breaking, with any sort of breaking into a car. So it really puzzles me to why in the opening statement, defense counsel we even mention about breaking into a car. This was a possessory crime, unless I'm totally mistaken, unless I got my cases mixed up.
No, yeah, so this was a possessory crime, but I think the connection here is
mention why even after getting a proper ruling from the trial court saying that you're not to mention anything about the car break-in, that defense counsel all of a sudden starts talking about it.
I think so. I think the issue is that this is a possessory crime, but it also encompasses the intent to benefit oneself. And so what happened is after the break-in happened, about a couple hours later, someone used these cards to try to buy an MTA, like a Metro card, unlimited Metro card, or they did actually. Right. And so if it were Mr. Parker who broke into the car, then that means that he was the person who had the cards the whole time and not only had the
counsel,
intent.
Whether he broke into the car and acquired the credit cards by breaking into the car, or acquired them from someone else who did break in, or a third party, who knows? It doesn't matter. And the court gave defense counsel a dream ruling. The people would not be able to elicit this testimony. Well, but then you can't open the door and make statements that attempt to misguide and misrepresent the jury. Then the people are entitled to clear that up. No.
Well, I mean, unfortunately, what the jury didn't hear was there was actually another suspect, it seemed, too, who actually committed the break-in. And the jury never learned that. And I think the reason it matters when he took possession of the cards is because they were used to buy a Metro card. That's clearly intent to benefit oneself. Did someone use them? But there's no evidence that Mr. Parker was that person.
I want to go on a different tact here. So despite the controversy, the evidence regarding the car break-in, just that it was broken in, was in fact in evidence. And the court's ruling pre-trial had to do with the argument that could be made from that fact. Right. All right. So it was in the record. But then the court, during his charge, was very specific in telling the jury what they could and could not use that evidence for, that they couldn't use it for possession and that they couldn't use it for propensity. Why don't we just end the story there? End of story.
So I think that the judge said that the evidence was used to show how the cards were stolen. And really all he said on this point was, if you believe he did break into the car, you can't use that to conclude he's a person generally predisposed to commit crimes. So just like kind of really general.
I agree with that. There were two pieces of the curative instruction. He said, you can't rely on that testimony if you choose to believe it. That he broke into the car. It's irrelevant. Don't consider it. Not part of the crime here. That's in substance what he said. And then he said, even if you believe it, You can't use it for propensity. Why isn't that any good? That to me seemed to have taken care of the whole matter, the whole problem.
Because I think that the issue here wasn't propensity to believe that because he broke into his car, he's just that type of person. I think the issue was, if you believe he broke into this car, then you think he had these cards this whole time and he already used it to benefit himself.
So why are you arguing Molyneux then? If it was a propensity problem. I mean, the whole gist of the argument, both in court and here on the brief, was that there was evidence of an uncharged crime, that it was Molyneux evidence.
Yes, so I think
no, it comes in on context that there was a break-in, that this stuff was stolen, not necessarily stolen by him, but that the property was stolen.
Yeah, so I think that it, for multiple reasons, makes it seem as though he must have had this intent to use, and that's the important part of the charge. And I'm happy to answer any other questions about that, but if I could just quickly discuss the second point, the second reason for a new trial, was the court, erroneously found as non-pretextual 2 juror strikes that were unsupported by the record. And happy to answer any questions on those, but there's one in particular I just want to quickly concentrate on, which was the striking of Miss Fields, who was a juror who had a nephew who had a juvenile adjudication. And that was the pretextual, that's supposed to be the non-pretextual reason given for striking her. However, nothing she said during the entire voir dire indicated any kind of negative feelings about the juvenile adjudication of her nephew. And she knew very, very little about the adjudication or what it was for even. To the extent she said anything about it, she just said that she felt like he was treated fairly. She didn't know anything about it. He didn't talk about it. He had no problems. And she also had cousins who were correctional officers. She'd been on a jury before. And so there was just no reason to tie her nephew's juvenile adjudication to an impact on her as a juror. And I think particularly when this court looks at the record and sees how she was treated and compared with Ms. Wool.
I'm going to stop you there.
Yeah.
Did you, or did not you personally, but whoever was trying the case, then seek to reopen the Batson when the circumstances with Ms. Wool came up?
Surely I would love if they had. They did not. But I think
yeah, but isn't that part of our consideration? I mean, the judge made a ruling based upon what he knew at the time, and Ms. Wool had not come up. So if you don't raise it to something that should give a reconsideration to it, how can we hold the judge accountable for that?
I guess my response to that would be twofold. First, that this is just yet another reason, in addition to the ones defense counsel did say very explicitly. The counsel said that there was no connection to this juvenile adjudication. She knew nothing about it. She had a correctional officer. Everything I just said, defense counsel also said. And then this court does have, the ability and the right to look at the entire record when determining whether a reason was pretextual.
But I'm going to stop you there because the record would not have been fully developed unless the argument was raised again. And then we could find out what, if anything, the prosecutor believed was different about Ms. Wool as opposed to the prior juror. I mean, so my concern is not even with your argument, but that we don't have a record here that in the Batson mode that would allow us to figure what, if any, influence the failure to preempt Ms. Wool had on your argument.
I understand. I do believe this court can look at the record as a whole, but I do think this argument can also rest on what the court did know about what Ms. Fields said at the time. Yes.
At the time.
Thank you.
That's a different issue. Thank you.
We'll have time on rebuttal. Okay. Ms. Gleiner?
Thank you, Your Honor. May it please the court. I think as the panel has indicated, it's clear that defense counsel opened the door to the argument about the break-in. Clearly, the defense had gotten a very good ruling, and until the defense opening statement, that ruling would have been adhered to, except counsel chose to use it as a sword rather than just as a shield. The other thing
did the court indicate after its ruling, make any comment with respect to warning defense counsel about what could open the door and caution them?
I don't know if there was a caution, but I think that it's a assumption that if you try to use evidence like this, if you say there is no evidence that my client broke in, that the other side is entitled to point out whether there is evidence. Quite frankly, I think the judge.
Well, there was no evidence that he broke in. There was evidence that he had the fruit of the crime later. But there was no evidence that I'm playing. You see, I'm playing devil's advocate.
I do see that, but
there's there was no evidence that he broke in.
Two things, Your Honor.
It seems like a gotcha. I'm going to give you this good ruling, and then the moment you say anything, the door is open.
Okay, Your Honor, I have two things to say about that. First of all, I think the ruling was a boon. The original ruling was a boon to the defendant, that because as one of the other justices pointed out, this was not a break-in case. This was a possession of stolen property case. In a possession of stolen property case, the people should have been entitled to point out the circumstances of the break-in and say, look, the circumstances of the break-in only happened the other day. Therefore, there is some evidence that perhaps this person was the person who broke in. But I think most importantly, whether he did the break-in or not, the evidence of the possession of the stolen property here was so overwhelming. What hasn't been pointed out is this is a defendant who was discovered with numerous credit cards belonging to this woman. He was a man. It was in the woman's name. And he was caught shoplifting. This is when the cards were discovered, shoplifting in Duane Reade. So the idea that the jury would not have found that he had the intent to benefit himself, whether or not he did the break-in, I think the evidence against this man was overwhelming, whether he did the break-in or not.
Let me just stop you. He didn't use the credit cards to purchase stuff at the Duane Reade. He just outright took that stuff.
No,
right?
But I think when you're considering someone's intent, the fact that they are in possession of stolen property at the same time they are shoplifting is relevant on the issue of whether they intended to benefit themselves. In other words, aren't you less likely to believe that this man was about, or this defendant was about to turn these into the police when you know he had them at the same time he was shoplifting? That I do think goes to the intent. Remember, the defendant is arguing that he had no intent to benefit himself.
Right. He wanted to give the cards back. He was going to give them back.
Well, as a juror, wouldn't you consider the fact that you were shoplifting in Duane Reade when you're considering a claim that I'm a solid citizen and I was about to give these cards back to the police?
I'm not going to answer that.
Do you want to address the Batson issue?
Yes, I do. First of all, in both instances, the prosecutor provided race-neutral reasons, and defendant doesn't even really contest that they were race-neutral. And the judge had every reason.
That's not true. She just argued here. She said they were pretextual. Okay.
No. On their I'm sorry, maybe I misspoke. On their face, they were race-neutral. In other words, when you look at a Batson claim, prosecutor.
But the issue is, were they pretextual?
Exactly, and that's up to the trial judge to then decide whether a race-neutral on its face reason is pretextual, and that's a credibility determination. The judge here properly found that there was no pretext. With the first juror, it was so obvious, even to the juror, that by watching crime shows and mentioning that she watched crime shows, that she would call attention to the fact that many people who watch these shows expect a different kind of standard from the people. With respect to the second juror, as has been pointed out, it's not even preserved, because even though counsel is now claiming that the prosecutor treated a subsequent prospective juror differently, the defense counsel never provided the court with an opportunity to even address the issue. So there's no record on that. So I think this court should defer to the credibility findings of Justice Conviser that this was not pretextual.
Any questions? Thank you. Ms. Byrne, you have a minute on rebuttal.
So yeah, just to quickly conclude on the Batson point. So I talked a little bit about why, on its face, even not looking at Ms. Wool, why, this is pretextual, and just how disconnected and unknowing the juror was about her nephew's juvenile adjudication, which is obviously very different from what she was there for. But I think also, the reason that I see it as very problematic is I think that typically cases involving strikes because of some kind of involvement with the criminal system have something to do with some kind of express hostility or express dissatisfaction with it, and certainly more of a knowledge of what even was at issue than the person had here. And I think, this can have a really dangerous effect of, disproportionately affecting people who might have family who have interacted with the criminal system, but they themselves have not and have no feelings about that. And just regarding the last point about reviewing the record, I would direct the court to People v. Hecker, which was discussed for a different reason about harmless error on page 28 of my brief. And in that case, actually, the Court of Appeals did look at the entire record, even though there'd been no preserved argument about the record as a whole, about the striking of other jurors regarding unemployment, and had said, the court had said, our review of the record establishes that people employed a general strategy to strike people who were unemployed. And, the same thing I think can be done here with regard to Ms. Wool.
Thank you so much.
Thank you.
All right. Gomez versus Vornado, 640 Fifth Avenue.
Yes, Your Honors. My name is Lester Channon. I'm an attorney for Curtis Partition, third-party defendant in this action. The appeal relates to a contractual indemnification claim by the general contractor Shawmut versus Curtis. And our position, we have sort of a twofold argument. One is that the Shawmut is claiming that they're not seeking indemnification for their own negligence, which of course would be barred under the general obligations law, but rather only for their statutory liability under Labor Law 241, paren 6, pertaining to tripping hazards on the work site. The problem with that argument is that although it's true that the general contractor does not need to be negligent, or rather, I'm sorry, there does not need to be a showing of negligence for a general contractor to be found liable under 241-6. There does need to be a finding of negligence against somebody in the chain of construction. And in this case, there's only two potential, a cast of characters of two, literally, which is Shawmut and Curtis. Curtis is a third-party defendant. Shawmut is a direct defendant. We have demonstrated through our papers and the record that Curtis had no negligence in this action, no fault whatsoever. And
how do we know that? Can I? Yeah,
Judy.
I know you argued that, but how do we know that? The plaintiff tripped on electrical cords. There were multiple contractors up there, including Curtis, who used electrical equipment for what they were doing. The cords, although you had testimony that you had a general practice, nice and neat, you put them in the gang box, that it sounds great, but we don't know, we can't identify the multiple cords and who they belong to at or about the time of the accident. So how do we rule out that one of those cords wasn't Curtis's?
Well, it's our position that the ownership of the cord in and of itself is not the significant or material fact. The material facts are who was responsible for making sure the work site was in a safe and organized condition, and that was 100% Shawmut. After all the other contractors left the day before the accident, at 2:30, Shawmut's laborers, as they always did, came in, cleaned the space, organized the space according to their own site supervisor. They checked to make sure that there are no bunched up wires. Flat lying wires are perfectly permissible. That same site supervisor walked through that space after they finished their work at after 5 o'clock in the afternoon, long after the Curtis and the other contractors finished their work, and found it to specifically found the wires to be laying flat. Okay, and also,
counsel, here we're being asked to consider the indemnification provision, correct?
Correct.
And does that provision in any way require negligence?
The They are claiming, Shawmut is arguing that
What
they're.
are you claiming?
What is it?
What are you, I
No,
wanna know
I'm
what
saying
your
that
argument
the
is,
only
because
claim
lang-
they're making under the indemnity clause is based on statutory liability. I'm saying that the only way they could be statutorily liable is if some contractor was negligent, but
and
Curtis
what I
was not
asked
negligent.
you to show me what language specifically in the indemnification provision at issue here speaks to a finding of negligence as a trigger. That's not how I am
Well-
reading the language, but please show me how
Well-
I am wrong. What
Our
am I
argument is
missing?
twofold. And the second part of the argument relates to that trigger as you're speaking. The first has to do with the fact that the only claim that they're seeking contractual indemnification for requires negligence by somebody, and it's not Curtis, it's only them. Now,
Where
as
is
to the other one,
language in the council? I've asked you 3 times.
okay,
now.
I'll answer it. I apologize.
Please.
Okay,
What
so
language
Your Honors,
specifically in the, please let me finish my question.
yes.
What language
Okay.
specifically in the indemnification provisions at issue specifically say that negligence is a trigger?
Okay, it's the words caused in whole or in part by any act or omission of the subcontractor.
I don't hear the word negligence, and our jurisprudence has not interpreted that language that way.
Well, the Court of Appeals has interpreted that language under the plain meaning of that language as precisely requiring a showing of fault or proximate
Counsel,
cause.
okay. Hey, counsel, this is Judge Owen. I want
Yes.
to take what you just said about indemnification, your contractual indemnification under your contract here, right?
Yes.
We're looking at that. How do you explain then, yes, you are to provide contractual indemnification if your client is negligent in whole or in part, correct? That's pretty clear. And you're
Or at fault in some way.
Okay, hold up. And then your argument, and let's say and you're correct with your argument, that your client, Curtis, is not at fault. So therefore, your client should not have to indemnify the GC or the owner, correct? That's
Exactly.
your argument.
Yeah.
But how about the second half of that indemnification clause, which says, regardless of whether or not caused in part by the party indemnified hereunder, which means then that would be the GC and the owner. If they're partially, because we know under general obligations law, you can't indemnify somebody for their own negligence 100%. If it's they're 100% liable,
yes.
But this says in part. So if the GC or the owner, we don't know this because we haven't tried this case, but if they're found directly liable in part, partially, 1%, under this reading, unless I'm reading this wrong, this requires contractual indemnification.
Your Honor, that interpretation is completely consistent with the Court of Appeals decision in Burlington, whereas if there's 1% of proximate cause on the part of the insured.
That's my point. We don't have a finding yet, though, right?
I'm saying that we have demonstrated, they went through that space 3 times. 3 times, Shawmut went through the space and found the wires to be lying flat.
I'm not disputing that.
They admit it.
I'll give you that. But there's no specific finding with respect to percentages of liability. I give you that. Okay, you're right. But there's not, unless you got somebody telling you this is the finding, boom, percentages of liability, 0 to the GC and the owner, then you're correct. I don't want to have to indemnify these guys. But if they're found 1%, like in Burlington, you're on the hook, it sounds like.
I tend to agree with that, but I think the record shows, but I believe the record can show as a matter of law that there was no fault on our part.
No.
Yeah, I do. I have one other question about the interpretation of this particular indemnification clause.
Yes.
I understand Burlington, and Burlington did have very similar language. What Burlington was discussing, though, was liability. It was indemnification for liability. Does it matter here that the scope of the indemnification is for claims and not liability with respect to your interpretation of the issue of what type of causation is necessary? Hard one, huh?
I don't, but yeah, I struggled over that. I don't know that I can clearly split that log.
I want you to take some time to ponder that. And I'm going to go to your adversary and we'll come back to you on rebuttal and give you a chance to come up with a response. Okay, counsel for respondent.
Good afternoon, Your Honors. May it please the court, I represent the respondents. For one thing I wanted to address really quickly, counsel said twice, he said the only way that Shawmut could be found liable under Labor Law 241-6 is if someone was negligent. And that's just absolutely not true. 241-6 is statutory non-negligent liability. So that's just a misstatement of law. I'd also like to point out that
but it is a vicarious liability.
Yes.
So it's if any other person on the job site has done something negligent, then 241 strict liability would cover Shawmut in their capacity of general contractor, right?
Yes, Your Honor, but
so he's not really wrong. I mean, we understand what he's saying, right?
Okay. Yes, but no, that doesn't have to be any. No one could be found negligent, but Shawmut could still be found liable under 241-6. I'd also like to point out that, and this case law that bears this out, that even for Labor Law 200 liability, you can't pass Labor Law 200 liability, of course, because that's active negligence. But on those cases where there are Labor Law 200 claims, and those are dismissed as against the general contractor, then the general obligation law isn't triggered. So that's just another point is that Shawmut could push 241-6 liability and 200.
Let me deal with another point, which has to do with what I asked Mr. Channon to begin with. Is it really undisputed in this record that his client is not negligent?
No, Your Honor, and there's plenty of case law that deals with. Well, first of all, this indemnification agreement doesn't even require a finding of negligence. It's much more broad. It's arising out of, resulting from.
Well, that's a different issue. But if he's right in his interpretation that this is a Burlington case, I don't know whether it is or it's not. But if it is, then has he established, or is there any issue about whether Citron was negligent or Curtis was negligent?
There's nobody knows who put those cords there. It's quite possible that the cords were shifted. Earlier in the day, when the superintendent walked the site, he said they were he said they were not. They weren't strewn about. They were properly bunched up. And then these guys, the Curtis guys, were moving sheetrock through the area with a dolly. It's entirely possible that the two of them, in the course of the plaintiff and his partner, the other Curtis employee, in the course of moving this stuff through the air, they could have knocked those cords there. And it's also
so counsel, I mean, I'm sorry to cut you off, but okay, this is my understanding of the argument is that your client is cross-claiming against Curtis for contractual indemnification, correct?
Yes, Your Honor.
Right. And they're looking to dismiss that contractual indemnification because their argument is that Curtis was not negligent. So therefore, I don't owe them any contractual indemnification, correct? That's essentially what they're hammering away at, that Curtis was not negligent.
Yes, Your Honor. Right?
But there's another part, and I mentioned this, there's another part there that triggers, and this is what we were all asking about, what triggers the indemnification? There's another part, you're looking at 241 issues for your client's vicarious liability. That may well and fine if that was the only, if your clients were held vicariously liable, an argument could be conceivable that there's no indemnification there because there's been no finding that your client was negligent, because the clause that I'm looking at requires some fault from your client in part, 1% or whatever, if for that indemnification clause to get triggered. And we don't have that yet, right? We don't have that. We don't have that finding yet, right?
There's been no finding of negligence against anybody.
So that's why that this indemnification claim, this contractual indemnification clause, is very broad in the sense that when I saw it, it's not only the indemnitor, but it's also saying the indemnity, if the indemnity is partially liable or partially at fault, it triggers indemnification. It's usually, it doesn't have that tag there, that last hang sentence.
I would agree it's a broad clause, Your Honor. I would also like to point out that Burlington is not on point here. Burlington, the analysis of the Court of Appeals in Burlington, first of all, it relates to an insurance procurement clause, not to a contractual indemnity agreement, but also they clearly state, we conclude when an insurance policy is restricted to liability for any injury caused. So they're trying to cherry pick cause in whole or in part. They're pulling it out of context. The indemnification agreement here is for any claims arising out of or resulting of and caused in whole or in part. It's a totally different and much more broad.
For your client, it's in part, because we know in the general obligations law, you can't indemnify somebody for the 100% at fault. But this one says in part. So we got to find out if your clients were in part at fault, and we don't know that.
Yes, there's been no finding of negligence for anyone.
Thank you so much.
Thank you.
Okay, Mr. Channon, you have 1 minute.
Okay. As to the liability issue, it seems that the insurance, the one in the Burlington case, speaks of liability, but of course, in the Burlington case, as in all insurance cases, there is a concomitant duty to defend. So it's a similar sort of an indemnification provision in that it provides for defense and indemnification, or the policy contemplates defense and indemnification. We would argue that as far as the argument that the helper with Gomes might have seen the cord and should have warned him about the cord, he's not in the record. He's not been deposed. We don't have any evidence from him. He's no longer an employee. So it's just purely speculative that he might have contributed to the accident.
Okay.
All right.
Thank you so much.
Thank you.
All right. Well, Wenzel versus All City and 217 East 88th Street and 212 East 89th Street. Counsel for appellant. You have 4 minutes.
Thank you, Your Honor. Good afternoon, Your Honors. May it please support Thomas Riley, Brody O'Connor, and O'Connor on behalf of the appellant. This is a very straightforward case. Ms. Wenzel was a long-term tenant on the first floor of our client's building. She had noticed about 2 days before the incident in question that when she came back from working nearby at lunchtime, she saw some dust in the areas throughout her apartment. She made an email out to our client's property manager, and within about 3 minutes of getting that, they immediately contacted the contractor who was working immediately above her apartment on the second floor, doing a complete renovation of that apartment, to have him go and take a look and inspect the conditions upstairs, what's going on in her apartment dealing with the dust condition. He and our client's superintendent did get into the building. I believe it was on the second attempt, got into the building, went through, they looked at the ceiling, the complaint. We specifically asked Ms. Wenzel what she was complaining about. She said there was a bulge in her ceiling in the living room, and she said that there was dust in her bathroom, her kitchen, and what she had was a smaller bedroom where it was on the bed frame and on her leather couch in the living room. They observed cracks in the living room and in the kitchen area.
I'm going to stop you for a minute because I we're familiar with factually the record. So here's a question that I have for you, though. The landlord was the one doing the work upstairs in the apartment directly upstairs. The landlord's contractor. The landlord hired somebody to renovate it on behalf of the landlord, right? The whole apartment, though.
Correct.
Similar kind of work, gut renovation.
Yes, sir.
There was no different work being done in the bedroom than was being done in the living room, where cracks where everybody admits cracks were observed.
That I can't address, Your Honor, because the the floor was taken up to put a new floor in throughout the entire property.
Throughout.
In that one. However, the contractor, Mr. Borger, I believe it is, who was the carpenter doing it, said he had to do sister joints in some of the different areas. And that was what was needed with regard to using a pneumatic, I believe, screw gun and I guess a pneumatic nail gun. I'm sorry, pneumatic nail gun and an electric screw gun, which he said created vibrations. Did not testify as to what area in the property it was. However, when our client had gone to Miss Wenzel's apartment, there were no cracks in the ceiling in her bedroom, which is what she's
But she complained about having dust over her bed and expressing concern that something could happen.
Your Honor, if I may, the dust she testified she had what she called a smaller bedroom and my bedroom. Where she was in her bedroom, she said absolutely within hours of her going to bed and being hit at 5:30 in the morning, there was nothing at all wrong with that. And she did not testify anything at all about dust in hers. We specifically asked her that. And in the record, if you look at page 92, 492 rather, of the record, she expressly says, the funny thing is, I don't remember if I saw any dust in my bedroom. So what she had testified to with regard to the dust on the bed was in what she termed the smaller of the two bedrooms. So it was not in her bedroom. The cracks, she never had any cracks in there. She never had any problems. She was a long-term tenant. She said absolutely never had a problem with that. She testified that the area that and we asked her again specifically,
the question is, your client knows this construction in the apartment above. I mean, this is just on the notice issue. I just don't, and maybe you can further elucidate this for me. I just don't understand. Somebody comes to you and they complain that in various parts of their apartment, while construction is going on upstairs, that your client is certainly aware of because they hired somebody to do it, that isn't noticed, that there might be, that there's a potential problem with a ceiling fall, which did fall. I don't understand. You mean if she did, if the ceiling fell in the living room, but it wasn't a result of the two where the cracks were, it was 6 inches away from the cracks, that the cracks wouldn't be notice of that? That doesn't make any sense to me.
Well,
I mean, at what point do we say it's not the whole apartment, it's room to room? I really am having trouble with this kind of quartering argument that you're making about particular cracks and it not being indicative that the work upstairs is creating a potential problem for the people downstairs. Explain it to me.
Sure, Your Honor, if I may. She has multiple bedrooms in this apartment. It's not a studio apartment where it's one big open area. There's walls.
Is it a mansion? How many square feet is it? It's an apartment. It's a New York City apartment.
I was going to say, I don't believe it's a mansion. It's a New York City apartment. So I don't
it's a
believe
New York City apartment. Okay.
Absolutely. But she testified she had the separate bedroom, the smaller bedroom where the dust was, and she had her bedroom, which said she had none, and she did not ever recall seeing dust in there. She could not recall seeing dust in there. She never had any complaints about any cracks there. There's every single day, as we're speaking right now, there's renovations in hundreds, if not thousands, of apartments and buildings in the city of New York going on right now. Just because there's construction going on upstairs does not give you notice that there's a potential that something could go wrong and fall. Our client, when last contacted, was 2 days before the incident occurred. They went and looked, and at that time, there was no indication whatsoever that there was anything wrong with this. The plaintiff testified that the next morning, after our clients had been there, that she got up to the sound of the men working upstairs, or the man rather, working upstairs from All City in the apartment above. We don't know that wasn't created at that point in time. There's no indication whatsoever in the record that our client had any notice whatsoever about the specific.
We know that the work that they had been doing was causing cracks. So
in the other area of the apartment, correct? And she testified to. She said
right,
that.
Well, I don't know on what day they broke up the floor over her bedroom. So I don't know if that's what they were doing on that day, and if when they pulled up the floor in the living room, it caused cracks. One might surmise that when I do it in another room, the same thing may happen downstairs, but you'll have time on rebuttal. Counsel for respondent.
Good afternoon. My name is Melissa Lenowitz. I'm counsel for the plaintiff respondent, Alona Wenzel. May it please the court. I would like to address just a few issues that my adversary brought up. There are two places in the record, actually, where my client does indicate that she complained of dust in her bedroom. They're on the record, page 489 and 689 to 90, where she said there was dust coming from the front of her apartment to the back of her apartment, and we know her bedroom is in the back of the apartment.
Thank you. I thought I was crazy and had read from another record.
Nope. She definitely did say that. And also, when she got up in the morning, when the ceiling had fallen on her, she did not get up to the sound of the workers working. They weren't there yet. She got up to the crash and the assault of the ceiling on her bed and her head and her person. So she didn't get up to the sound of the workers at all. It was much before they started working. But also, the landlord's contractor admitted that it could have been the vibrations from his screw gun and his nail gun that could have caused her ceiling to come down. And when the contractor and the superintendent came to inspect her apartment based on the complaints, they found 2 to 3 foot cracks in the ceiling over the kitchen and the living room. Now, it was explained in the record in the deposition transcripts of plaintiff and a couple of defendants that this is the kitchen, living room, dining area is kind of one room. So it is a very small apartment and everything is very close together. And they had been doing work directly above her apartment. And the contractor testified that he got within 20 feet of her bedroom, installing the sister joists in the entire apartment upstairs. And that was when he said that the vibration could have created her ceiling to fall. And in addition to that, Judge Jaffe had held that they hadn't, that there were material issues of fact as to the actual notice, and that actual notice would be imputed based upon the third party creating the condition and the property manager and the superintendent inspecting. So that, they had a non-delegable duty, a statutory duty to keep the apartment in a reasonably safe condition, and they failed to do so. Now, another one of our arguments that I wanted to point out was that they had a duty to warn, which they didn't. They actually failed that duty by coming in, seeing these cracks in her ceiling, and telling her that she was safe, which we all know now she wasn't safe. And the appellant also had a duty to protect, because the plaintiff presented evidence that there was a hazardous condition. And when a plaintiff presents evidence of a hazardous condition, the burden shifts to the landowner to demonstrate that they're keeping that premises in a reasonably safe condition. And finally, we also believe that they're responsible under res ipsa loquitur, because pieces of ceilings don't fall just for, without anybody's negligence. And the defendant appellant had control of the ceiling, and doesn't need to be exclusive control, but they were in charge of the building, they owned the building, they maintained it, they were in charge of all the repairs, and the plaintiff was merely sleeping at the time of the incident, so she had no voluntary action or contribution.
Thank you so much. Thank you.
If I may, Your Honors.
All right. Yes, you have 1 minute.
Thank you. Well, the issue with res ipsa, we strongly disagree with. The co-defendant testified they were the sole ones working upstairs. Our client testified they were the sole ones working upstairs. We did not have exclusive control of the apartment directly above her. As counsel also said, that with regard to the duty to warn, you don't have to warn about something that's open and obvious and that you have knowledge of. She's trying to impute that our client had knowledge because there was a crack in one side that we should have known there was something.
A 2 to 3 foot crack develops over your living room and kitchen ceiling, and you don't have a duty with regard to that?
To warn,
really?
Warn that there's 2 or 3
You
foot.
You don't have a duty.
They already have. She was already on notice of it because she was observing it at the same time. So they already discussed that, and they said that there was a crack there in the living room. She had
right, and they also told her it was safe, and we know that was wrong.
Right, the living room never fell. It's a condition separate and apart from that. There were no cracks in the bedroom, and she testified there was nothing there with regard to that. With regard to the counsel's.
You have 30 seconds, sir. Wrap it up.
Thank you. With regard to the allegation about the dust, yes, page, as she had mentioned, page 4, I believe it is 89, it testified that there was dust from front to back, but we clarify that 3 pages later on page 492, when we asked specifically where it was, she went through the laundry list and she expressly testified, page 492 of the record. The funny thing is, I don't remember if I saw any dust in my bedroom. So she didn't say that there was dust in her bedroom.
She said she didn't remember. Thank you. All right.
Thank you, Your Honor.
Sorge versus Sharp Management. Mr. Steinberg,
Your Honor.
4 minutes.
Thank you, Your Honors. May it please the court. This is Jason Steinberg. So there are 2 issues, obviously, on this appeal. The first is that the defendants did not, in their moving papers, establish a prima facie entitlement to summary judgment. When you're dealing with the issue of a loose handrail or any really defective condition on property, but more specifically, the loose handrail, is the obligation of the defendant to demonstrate the absence of constructive notice. And in order to do that, they have to show when the area.
Does the fact that your client lived in the basement area where this accident occurred and traversed it daily and he didn't notice it, does that bear on this at all?
No, because the client last used the handrail 2 months before the accident. That was his testimony, that he did not use the handrail at all, for 2 months. But then the 2 months before the accident, there were no problems with it. But the property manager testified he inspects the premises daily. The property manager who says that was obligated to come forward with evidence proving when the last inspection was performed and what the observations were at that time in order to establish a prima facie case.
I thought he said he goes to the building once a week and walks through it. I thought that's what I read. Did I misread the record?
No, you did not. Did I just say daily by accident?
You said daily. I'm like, okay.
Oh, I apologize. That's my mistake. He goes once a week to the property to do his inspections. That being said, he's obligated under the law to show when he last inspected it and that there were no issues. That's how you prove your prima facie case in summary judgment context. I'm not talking about trial. DePini versus 381, 160 equities, 121, 83D 465, the First Department, this court specifically held in a loose handrail case. If you're going to establish the absence of constructive notice in your motion for summary judgment, you as the property owner have the burden of showing when the area in question was last inspected prior to the accident. There's also a Second Department case that says the same exact thing.
Mr. Steinberg, I'm sorry to interrupt. Maybe I'm confused, but doesn't the workers' comp bar trigger here? I mean, we're getting caught up with whether they had notice of the rail in the basement, but the central issue here is whether Sharp and Briggs are somehow linked, or whether your client was a special employee getting workers' compensation to bar this whole lawsuit. Is this the right case?
Yes.
You can disagree with it, but it's the right case.
No, that was the second issue. I said initially there's 2 issues I want to address. The notice.
I understand, but to me, getting into the merits of notice, I think the comp bar issue to me seemed to be a more significant issue to address.
Well, then let me address the first issue with respect to the owner of Briggs. There's an owner and a property manager in this case. And they're the defendant is arguing, when they certainly didn't establish prima facie, that the owner and the property manager are a single integrated unit. And that is the standard applied when you're trying to figure out the companies are alter egos of one another.
Didn't they pay the workers' compensation insurance that paid out the benefits to your client here?
The workers' comp, there was workers' comp.
That they
because
paid
he did work at the property, but that doesn't
counsel that the defendants paid for.
That's correct.
You don't generally pay for workers' compensation insurance unless you are doing it for your employees.
My client was employed by Staff Pro, which was an entity engaged.
Staff Pro is just a staffing company.
And then Sharp Management, if anything, this is a part of the argument on the appeal. Sharp Management, if anything, is the entity that would be considered the employer, not the owner of the property. Those are two separate entities. So they're trying to argue alter ego, and what they do is they submit an affidavit only.
Well, let me stop you for a minute. It's not really alter ego, because under the workers' comp law, and there are a whole slew of cases regarding that employers' organization into separate entities doesn't preclude a finding that an employee for workers' comp purposes can have more than one employer. I mean, that's black letter law, right? That's the Thompson case. That's right.
Right, but
all right. So you have somebody in the office. She provides an affidavit. I do have some concerns. Could have been some documentation that would have been helpful here, but she gives an indication of the organization of the business entities, and her claim under oath is that the workers' comp premium is paid on behalf of these entities for the benefit of the plaintiff. Is that enough?
no, I don't. The affidavit of an assistant office manager for one company is not sufficient to bind the other corporation. That's what I'm saying. That's why I've argued that this is not a prima facie case. There's no documentation. She alludes to a workers' comp policy, but doesn't attach that for the court to review. She says Exhibit H is the policy, but there is no policy in the record. So Judge Thompson can't just say, oh, the assistant office manager says Sharp and the owner are the same entity. They paid out the workers' comp policy with no policy to review. How can you, that is such scant evidence. They didn't establish the prima facie burden. And again, this is an assistant office manager that's employed with one of the companies. And that's consistent with all the employees in this case. You have the property manager.
Your client received workers' comp benefits, correct?
He did as the superintendent.
Doesn't that determination tell you whom is providing it under what policy?
But no, there's no proof of that as to which entity actually specifically provided the comp benefits. Is it Briggs? Is it Sharp? Is it Staff Pro? It's a little unclear here. So and they don't have the documentation to substantiate that. There's no policy. I can't answer that question. All I know is the office manager who's employed solely with Sharp. She says that I'm employed with Sharp. Says these two are the same entity. They do this, they do that. But I actually, in opposition, submitted documentation showing their opposite, that they're not the same entity. They were formed 30 years apart from one another. They have different addresses. They have different employees. And these are all factors that weigh against the finding that they're one and the same or operating as a single entity. In fact, one is the owner that pays for all the work. The other is the property manager that makes the arrangements. Those are two separate and distinct functions that these two corporations perform. The comp benefits, maybe it's Sharp, maybe it's Staff Pro, but there's no indication that.
Well, it's not Staff Pro. It's not, right?
All right.
Concede that. It's not Staff Pro.
Fair enough. But
okay. If
it's Sharp, the supervisors are set, they're employed with Sharp, not with Briggs. The Burko, the property manager, said that Briggs is an owner, Sharp, the property manager. He said it's a property management agreement. Again, not submitted as part of the moving papers to demonstrate that they're the same entity. I would imagine a property management agreement would indicate there were two separate entities, as a matter of fact, but we don't have it. So in your motion of summary judgment, sorry?
Thank you for your argument.
All right.
Okay. Ms. Subik, 3 minutes.
Good afternoon, Your Honors. My name is Sage Subik, and I'm counsel for the respondents, Sharp Management.
Just want to get you right to the point. Shouldn't your client, in order to have established, or clients, in order to establish the prima facie case regarding the workers' comp, have provided more than just an affidavit of an office manager, shouldn't the court at least have been provided with the workers' comp policy and other documentation that would otherwise prove what she is saying is true? Why should we just accept a bare bones affidavit?
Right. So I think what counsel was alluding to before is that there was an indication that there was supposed to be an attachment of this workers' comp policy to the affidavit in the moving papers, but for one reason or another, it was not attached. But she goes on to explain that.
Yeah, but that doesn't help you, but okay.
That doesn't, absolutely, it doesn't help. But I also think the plaintiff has never disputed that the workers' compensation was paid out in this case. And if you read the rest of the
fact that it's paid out is not the point. The point is under whose policy and what was the finding in terms of who was the employer for this worker. That's the relevant information.
Absolutely, Your Honor. And within that affidavit of this employee, the Miranda affidavit, she says both Sharp Management and 2886 Briggs Realty employed plaintiff. And that's in paragraph 3. And then
no doubt she said it, but that's a conclusion. What does she base it on?
So she has worked for this company for over.
Counsel, everything that she puts in the affidavit has papers that can support it. Where are they?
Absolutely, Your Honor. I think that the workers' compensation policy was supposed to be attached as Exhibit K, and since it's not on the record, I can't go speak to it. I think that if you continue going on, she is explaining that they have a single insurance policy that they paid, that they're both. I understand I do understand what you're saying, but the policy I don't have. And therefore, I know the plaintiff has already discussed that he believed that he worked for this company. They hold themselves out as an integrated company. They only have one insurance policy that they both pay a single premium under. He received his.
We don't have the document of payment either for any particular year. That might have helped.
There is no documentation attached to this. That's true. But it is proven on the record that the plaintiff has said that he got the payments from his worker compensation and that he worked for this company. So during this time.
But he believed he worked for the staffing company. So that doesn't help you either. All we have is the sworn statements and affidavit of an employee with no supporting documentation. You're asking the court to really put a whole lot of weight into that one affidavit.
Absolutely, Your Honor, but also the plaintiff did testify that he knew that he was supervised by the two defendants, Burko and Malowski, who are both employees of Sharp Management. So he believed that he worked for the same company as those two employees. So he wasn't sure which company it was. He knew that on the paychecks that was issued to him, it said Staff Pro, but he did believe that he worked for this company and he was supervised by them. They could fire or hire him. There was he believed he worked for this company. So he understood that to a degree. Again, not just the affidavit, but also the testimony of Burko and Malowski, they stated that, just as counsel said before, they would Sharp Management would hire the contractors to come in making whatever work, and then 2886 Briggs would pay for any sort of construction that would happen on the property. That is evidence that they serve the common purpose and that they are one single entity. They had one common business purpose. It was the same management. They both worked for both companies. They both had the same human resources department, the same common payroll. They held themselves out as this integrated company with the common purpose of ownership and maintenance of this property.
This is Judge Shulman. Didn't the plaintiff have a subsequent lawsuit as part of your papers where he claimed that Sharp never had any problems with his performance or attempted to try and replace him as a superintendent, which suggested he acknowledged that Sharp was really his employer and not Staff Pro? Wasn't that part of your papers?
It was part of the papers that he had after this lawsuit was fired. And I think it does go to show that he believed his employer to be Sharp Management.
Sharp Management, correct.
Sharp Management, but also that these are an integrated company. So while he might not have known the name 2886 Briggs, they operated as one management, as one company.
Thank you so much.
You're welcome.
We're out of time.
Thank you, Your Honor.
All right. Lopez versus 1355 Morris Avenue.
Good afternoon, Your Honors.
Good afternoon. You have 4 minutes, counsel.
Thank you. I think I'm going to just start off with, it's very clear Judge Armstrong missed the entire point of my argument. But without getting into the nitty-gritty, the video shows everything that you need to know. The video, you can see her walking down the stairs. She's texting and focused on her phone. She plants her left foot firmly on the second to last step. She goes to put her right foot down, and she clearly misses the last step. You can see her foot turn under as it goes down to the ground, and she goes straight down.
So this Judge Gish, what significance, if any, is the fact or not fact that the step is wet or not wet?
Well, that's part of our point. Our point is, it's clear that it should be an irrelevant issue because that's not what caused her fall.
I didn't ask you that. Is it factually? Do we know? Is it wet? Is it not wet?
Well, that's
Was
again,
it when the super cleaned and he said he swept, or did he mop? What was going on there?
The super claims that he swept, he didn't mop. The plaintiff claims that he mopped. She knew he had mopped, and that it was wet.
I didn't read that she knew he had mopped. She knew he had cleaned.
No, she actually testified that she knew he cleaned, and she knew that the floors were wet because he had mopped.
After she fell.
She knew, no, she said that when she left her apartment, less than 10 minutes after being on notice that he was outside cleaning, she knew that the floors were wet. Not that they were clean,
but they weren't wet. But they weren't wet because he only swept them, right?
But therefore, her notice, whether or not there was a failure to warn as the proximate cause, becomes a non-issue because she says she knew. So the negligence that she could be imputing to the landlord for this wet condition that she thinks was there, how does it go? Because she admits that, okay, they didn't warn, but she knew. And we all know if you know.
I'm sorry. What did she know? Did she know that they were mopping, or did she know that they were sweeping?
She actually testified that she knew the stairs were wet because the superintendent had mopped. That was her testimony.
I didn't see that testimony. Can you tell me where it is?
Okay, if you go to page 112 through page 117, and let me pull it up on the record here. Okay, I asked, she said, when you say the floor was wet also, on page 112 of the record, line 16, when you say the floor was wet also, is the floor outside your apartment on the third floor of the floor on the second floor where you landed? She answers, in total, all of it was wet. The whole, and then it says both floors, and she says the whole building, the lobby also was wet. They were cleaning. So she knows, this is her own testimony, even if she's wrong about what she knows that they were wet. She knew before she took the first step.
And just so that I'm clear, because I know you have a view of this, where in that testimony, there or another place, does she give you the temporal recitation of the basis for her conclusion that everything was wet?
Okay, let me find the one section where she says that when she left her apartment, that she knew that the floors were wet. And that's right before she took her first step. She knew that the floors were wet. I'm asking, this is on page 115, line 7. I'm asking specifically to the stairs, landing third floor. the top of the stairs to the second floor. Did you know at that time that the stairs were wet? Yes.
But what is that time?
That time is as she's standing at the top of the stairs before she descends the flight of stairs.
Okay.
So again, because her own testimony that she was on notice that the stairs were wet, obviously that couldn't have been a proximate cause of her accident. But again, the video clearly shows that her testimony has a lot of errors. Her testimony, she fell from 3 or 4 steps up and went boom, boom, boom down the stairs with her body hitting the stairs. The video, that's not what happened. So, I mean, this is a case where we really do not need to waste further judicial resources.
Okay, thank you. You'll have time on rebuttal. Counsel for respondent.
There's no reason for this court to reverse the lower court's finding. While there was some contradiction in the testimony with regard to where on the steps the plaintiff was caused to slip and fall, she clearly put an X at the 3rd step from the bottom of the stairway leading from the 3rd floor to the middle of the 3rd floor at the landing between the 3rd and the 2nd floor. That is found in the record at record 190 and record 121 to record 122. Peculiarly, at record 190, there is a picture of the plaintiff lying on the floor, a woman who's her mother sitting there. Obviously, they were then waiting for the ambulance, and the broom of the superintendent leaning against the wall. The super said, "I was not mopping that day. I was only sweeping." But he said, "I was up on the 4th floor," and everybody agrees he went up to the 4th floor to be cleaning. And the word cleaning was bounced around by everybody. The word sweeping was bounced around, and the word mopping was bounced around. But when the super said he went up to the 4th floor to be cleaning, he said, "I was only going up there to sweep with a mop, with a broom." But
So but the claim by the plaintiff is that the floor was wet from mopping.
Well, the plaintiff utilized the word cleaning over and over again, but the plaintiff also, between page record 112 and 118, indicated that the whole building, all the floors were wet from cleaning. Although the plaintiff used the word cleaning, and the word cleaning could mean sweeping and mopping, or just sweeping, or it could be.
But you don't sweep with water, counsel.
Pardon me?
You do not sweep with water. You only mop with water.
Oh, absolutely. And the super said I was only sweeping. I was not doing.
Why would the floor be wet? If he was only sweeping, then her statement that the floor was wet, there's a disconnect between those two things.
There is a question of fact. He says I wasn't cleaning, meaning I wasn't mopping. I was just sweeping. She says that he was cleaning and that the floors.
We get that, but here's the question. Is your theory of liability that she slipped because it was wet?
Yes. The video.
Okay, that's your theory. So now I'm going to ask you, when did she know it was wet?
Yeah, well, she should have known. She should have known when the super knocked on the door and had a 10-minute conversation with the plaintiff's mother, and she observed that he was cleaning, meaning mopping and sweeping. And then when she went out about at least 10 minutes later to take the child to school and to go to work, and in which she was admittedly looking at her cell phone, and there will be a question of comparative or contrib. There's no question about that.
But I want to get to the heart of your adversary's argument about failure to warn, that she knew about the condition and therefore the failure to warn did not cause her accident. How do you address that? That's a central argument here.
That is comparative negligence. she observed that every floor she saw was wet from cleaning. Again, she used the word cleaning. You can't make a floor wet from sweeping.
But was that before or after she fell?
Exactly during and after. And before, had she not been looking at her cell phone and not been mindful of that there was a mopping of the floor, but there were no yellow signs there, so she was not mindful of it. She was not warned about it. That would be an issue of fact as to whether there's.
So what do you say about your adversary's claims that the deposition testimony establishes that she knew it was wet before she fell?
She knew it was wet at a period of time when the superintendent knocked on the door, allegedly to talk to the mother and or mention something about, I'm over here now. I don't know. I don't know what period of time transpired. It's not in the record. In addition to the 10 minutes, but
that was before the fall.
That was at least 10 minutes before. It never got into the record. How much more than 10 minutes was it when the super knocked on the door? They had a conversation of 10 minutes. It doesn't take 10 minutes to say, ma'am, I'm mopping the floor. But that was what happened. It seemed to be as much of a social visit, a friendly visit. But the plaintiff said, yes, I observed that he was cleaning, meaning mopping, not sweeping, the floor where our apartment is on, which is the third floor. So
I think we've got it. Thank you. All right, you have 1 minute.
All right, first I want to address how much time went by that specifically was asked and answered on the record. Page 117 of the record, line 19. From the time you were making the coffee, she testified that first I'm going to go back, she testified that she was making coffee when the super knocked on the door. So from the time you were making coffee until your accident happened, how much time passed? And her answer, not even 10 minutes went by. Wasn't a 10-minute conversation.
Okay, let me just stop you for a minute. Do you agree with the proposition of law? You think this is accurate to say that regardless of the duty to warn, that the owner still has a duty to keep the premises in a safe condition?
There's nothing here that says it wasn't in a safe condition.
So by that answer, I'm going to say you agree with that proposition.
I agree that they have a duty to keep it in a safe condition. Okay. But I do not believe that there's anything here that says it wasn't in a safe condition.
If
and as the video shows,
if the floors were wet, is that safe?
Yes, the daughter proves it. The daughter runs up and down the stairs, even after her mother falls. And then, of course, the photograph that my adversary refers to shows the mother sitting on the stairs, the exact stairs where she says she fell from. Okay. I mean, there's really not much here to be tried. It's pretty clear.
Thank you so much.
Thank you.
All right, and
thank you.
Lemon versus Lemon.
Good afternoon, Your Honors. This is Matthew Keston. May it please the court. My firm is representing the appellant in this matter. And candidly, as I see it, there's 4 issues that emanate from Judge Sattler's decision, all coming from this very detailed protocol that the parties have in their agreement for resolving major issues. And this relates to both camp and school, which are the issues that are before the court today. The summer camp one, to me, is the easiest one. Judge Sattler just missed the boat on that. The agreement says summer camp is a major issue. Judge Sattler said it wasn't a major issue. It's conceded that the mother didn't comply with the agreement at all. You had to talk to the other person. You had to try to come to an agreement. Then you had to go to a PC. You had to hire a professional. If you couldn't come to an agreement, she did nothing. My client reached out. My client's the only one who tried to comply with the agreement. He reached out. In response, the mother said, I've already signed her up. And some months later, she sent them a bill. That was it. That's certainly not compliance. I know that's the smaller of the numbers that are out there. It was about $900 to $950 that is being sought. That needs to be reversed. That segues into the school issue. Again, I don't see anything in the record that suggests my client didn't comply with the agreement. In fact, the mother didn't comply with the agreement. The school is very simple, just like the school, just like the camp. You had to try to come to an agreement. If you can't come to an agreement, there's a protocol for trying to resolve all the issues. My client tried to do that. He's on record repeatedly as saying, I don't agree to this particular school that you're proffering. And by the way, to the extent that anyone claims his refusal was unreasonable, you have in the record, the mother applied to a bunch of private schools for the child. 3 of the schools sent out letters saying, we don't want to take her, she's too young. They had an admission expert that the parties had hired to assist them in the process. She said the same thing. The preschool that the child was already in said the same thing. You have 5 independent people saying the same thing. So you can't say it was unreasonable. The mother just up and assigned the kid and signed the kid up without any consent, without going through the protocol. How under that scenario anyone could suggest that my client did something wrong, which segues to the third issue, Your Honors, which is I don't know how it is that Judge Sattler suggested that my client violated the agreement because he did not run to court to complain about what his ex-wife had done. There's nothing in their agreement that suggests that if you feel aggrieved, you're the one that's required to run the court to try to get the court to overturn what your ex-spouse did in contravention of the agreement. The general
Well, if
law,
someone doesn't follow the protocol of the agreement, how else do you? It would seem to me that's what you have to do to get the parties back on track, no?
I don't think so, Judge. I think, unfortunately, the way the authorities that I read come out is that whoever does that.
If you are suggesting that the result should be, well, you didn't follow the agreement, so I'm not going to pay, and the kid is the one who's stuck in the middle without getting what he or she needs, is that would be the right answer. It doesn't seem to me that
No, not at all, Your Honor.
That's the right answer.
Not at all, Your Honor. The child was
so
in
if the
school.
process breaks down, that and one side is refusing to follow the process, it seems to me the only thing you can do is go to court and ask to compel the process to be followed, no?
Or you can follow the authorities that we've cited to you that suggest that the person who's violated the order should be solely responsible for the costs of their decision. And that's what we're suggesting.
What authorities?
If you looked in my brief, Your Honor, I have a bunch of authorities we cited that
you mean cases. Okay. I thought you were talking about agencies or something. I wasn't sure what you were referring to. Okay.
I apologize. I know you read the briefs, Your Honor. I know you read the record that's before you. We've cited several cases which talk about the person who's violated the agreement. She has to suffer the consequences. So the child is not left in limbo. It just means that you're going to bear the responsibility for those costs.
This is Judge Owing. I have a question about what you just said about the authorities' cases support you. But do those cases have the same type of agreement that we have here, where if they can't get along or they can't resolve it, to go back to the court to resolve the situation?
They don't say that, Your Honor. They're not matrimonial cases. They're general cases about agreements.
Right. So they don't.
I didn't find any of that.
Right. We're dealing with a very unique. This agreement here, my understanding is that we have two parties. If they can't see eye to eye and it's a stalemate, their remedy is not self-help, but their remedy is to go back to the court to figure out what happens, right? And in this case,
yet.
Well, eventually.
Eventually.
Eventually,
somebody could have
somebody has to make a decision, right? The kid goes to camp, the kid doesn't go to camp. The kid goes to school, the kid doesn't go to school. If they can't make the decision, there's nothing in their protocol or outside their protocol that says that they can just either one of them foist the cost onto the other. It says you got to get a decision maker to decide. Yes, you're right. She should only go to camp 2 weeks a month or 2 weeks for the summer. Or no, she should go 8 weeks. She should go to this camp. No, she should go to that camp. Somebody's got to make a decision, right?
I don't disagree, but for the Judge Sattler to then say my client was in default where there's no obligation for him to be the one running the court and then sock him with attorney's fees.
Is it, honestly, she didn't hold you in contempt, which I think was right? So goodness gracious, we're not fighting with that. We're just talking about the financial repercussions under the agreement for the decision about, let's talk about camp. She said, okay, camp. She did make a mistake, I'll grant you, and everybody agrees about whether it came under the protocol or not. And it seemed that neither side followed the protocol, okay. But that doesn't change the fact that it was in court and somebody had to decide, was camp right or camp not right? Should the kid have gone to do a basketball camp, I think it was the father suggested, or should the child have gone to the camp that she went to for the last 2 years, at least for 2019, right? I mean, what
can I throw one thing into throw one thing into the scenario, Judge?
Of course.
The one thing you're missing, the one thing you're missing there is that when my client reached out to try to work out the summer arrangements, and all the wife said, his ex-wife said, was, "I've already signed her up." There was no attempt to go through the protocol.
But
So you don't just run right to court.
It's not about rewarding or hurting people. Quite frankly, what I saw in the record is that your client finally raised it June 24th. Your client knew that the arrangements for the child, they had joint custody, that they should have been talking about camp months before. Everybody knows that. Everybody who lives in New York City knows that you have to figure out a child's camping arrangements months before. And it wasn't raised by either of them. A pox on both their houses. But that doesn't impact that the child, whether the child should or should not have gone to camp in 2019. I mean, that's really it. I think we're not seeing the forest for the trees, either side here, quite frankly.
Well, can I ask a question then? I usually don't ask questions.
Okay, no, we don't. Counsel, we don't do asking questions of the
Then I
court.
would point, then I
You
would
have the
point
roles
out.
reversed and you can speak during your rebuttal time.
I'll do
Counsel
it during
for the
rebuttal, thank you.
respondent. No. Respondent?
Thank you, Your Honors. May it please the court, my name is Matthew Ehrlich with the law office of Matthew H. Ehrlich, LLP, for plaintiff respondent, Rakesa Feaster-Lamine in this matter. There has been a consistent history in this matter of the defendant simply stopping at nothing to try and avoid making payments for his daughters, be it education, health, extracurriculars, camp, and he's continued to do it even after they signed the financial stipulation of settlement, which our hope was that these issues were finally resolved. The trial court absolutely got it right when it said there's a pattern that emerged where the appellant does not object, whereby he states that he does object without pursuing any legal avenues, and then uses that objection in an effort to simply not pay. He did it during the divorce action, and he's done it afterwards. The appellant has brought up again the decision on the child's private school education at ECFS, which has been drawn out and dragged out ad nauseum throughout the litigation in this matter. And it really is irrelevant at this point because the parties signed the financial stipulation of settlement 2 years after this child already started attending ECFS. That's ethical cultural fields in school.
For where?
I'm sorry? Okay.
Where?
Gotcha.
It doesn't matter what the name of the school is, but okay.
So in the financial agreement, the parties agreed dad's going to pay 25% and mom's going to pay 75% of the child's education. Okay. There was no dispute at that point that the child was attending ECFS. Dad was simply.
That was in 2017.
That was now in 2019. This is now 2 years. 2 years
right.
after.
Thank you.
Okay.
Right.
And so the child had been attending ECFS for 2 years when they signed the financial stipulation of settlement. The defendant was well aware of this. If the defendant truly did not want to pay anything for ECFS, he could have easily put a provision in the financial stipulation that said, I'm not going to pay 25% of ECFS, but I will pay 25% of any further private school that we come to an agreement on. He didn't say any of that. He just relied on what he thought was an ambiguity in between the financial agreement and relating to the custody agreement, and he was going to rely on that potential ambiguity to avoid paying, as he had done for basically the child's entire life at this point. There was no question, and there was no issue raised by the defendant since the child started going to ECFS. For the last 4 years, he didn't say, now I don't want her to go there, I want her to go to a different school. And by the way, the parties had agreed that the child was either going to go to private school or gifted or talented public school. Those were the only choices. The defendant has offered no other choice. He's just simply relying on, I didn't agree to this, so therefore I'm not going to pay. And if you just abide by what the defendant is saying, then he's not going to pay anything through the child throughout the child's entire education, which is simply not what was tried to be done here. If we're talking about the decision-making process, Rakesa did go through the entire process. She didn't breach the custody agreement. She went to the parent coordinator. She abided. She went to the parent coordinator for over 30 days. The final meeting with the parent coordinator was 2 days before they had to make the decision for the child's private school. The parent coordinator just simply would not make a decision in this case. So my client was now left with the decision that as everyone knows, the private schools bear down, and if you don't make a decision by February 17th, sorry, you're out of luck. So now they're left in this sort of purgatory. What do they do? The defendant then sends my client an email on the 16th, on the eve of the decision, and says, I don't believe that Raya is ready for school because she's too young. However, all of a sudden, she's magically ready to go to school if my client pays for the entire first year of kindergarten. So at that point, his whole objection that Raya was too young or not emotionally ready is simply used in an effort just to not pay. So my client signed her up. There was no other choice at that moment in time. The defendant did not have another alternative. While he suggested Mandel I suggest Mandel, he did not try and sign the child back up for Mandel. He did not try and pay a deposit for Mandel. And what he failed to tell the court is Mandel was only for one more year anyway. And even more than that, he could have at least paid his 25% of Mandel's preschool if he truly felt that the ECFS was not the right amount. But he didn't do that either. He simply takes no responsibility for this. In addition to
wrap it up.
Okay. In addition, with respect to camp, the child had been going to the same camp for several years. She'd been going to camp for 6 to 8 weeks for several years. The defendant did nothing to try and offer a camp until after the financial stipulation and settlement was signed. And my client had already signed her up because that's the camp that the child had gone to for several years. And finally, with the occupational therapy, it's important to the court to know that while the defendant...
I thought that argument was withdrawn. You don't need to...
It is withdrawn, but he still hasn't paid the money. He withdrew it, but he owes $750, but he still hasn't paid her.
Right.
So... Thank you very much.
It's not on appeal. You have to get enforcement some other way. You have a judgment.
I understand.
All right.
Thank you for your time.
Thank you so much. Mr. Keston, you have 1 minute.
I will do my best, Your Honor. So I want to correct the few misstatements that Mr. Ehrlich made. First of all, it's not a 75-25 agreement. It's a 75-25 financial agreement, quote, subject to the terms, close quote, of the custody agreement. So it's not just whatever she wants. And that's what's happened through this. She's done something, she does whatever she wants, and she ignores the agreement. Secondly, he did suggest another school. As Mr. Ehrlich suggested, it was Mandel. That was pre-K. Of course, it was only for the 1 year because that was the last year of pre-K. And you have it in the record. And you have 3 other schools suggesting that the child should have stayed in pre-K. Everyone but the former wife was saying that. So third, he did object repeatedly over and over and over again to ECFS. He didn't want to go. The record is replete with that. And that should have gone forward for the protocol.
Why did this kind of wind its way into the court for the court to say, yes, I will decide where the child goes to school? I don't get it. And so what happens now? Every single year we're going to have this? This is just nuts.
It may be, Your Honor, but that's unfortunately the nature of their agreement. Unless the court is going to
actually, I don't necessarily think it is. I don't think the nature of their agreement is withholding payment. I don't see anything in that agreement that says you can withhold payment. There's a dispute resolution mechanism. You got to go through it, and ultimately, if they can't decide, then guess what? The court just decides.
Which would have been fine.
Well, that's what happened in Camp.
No, it didn't happen, Judge. That would have been fine, except that the wife or the ex-wife didn't follow that protocol. She's the only one that violated the statute.
Neither did you. So instead of an appeal,
no, she didn't. She went to court to enforce it.
Nobody did.
Right. So how is my client in default? And how does he get socked with 7,000 in attorney's fees when he did absolutely nothing wrong?
Because
That's
the
my-
agreement that he entered into at the end of the marriage said so. Thank you
Says
so
if
much.
it was a default.
This is the end of the session of the appellate division. Thank you. Have a good evening and enjoy the beautiful weather. Have a
Thank
good
you,
night.
everybody. Stay safe.
Have a
Thank you.
good night, gentlemen.
Bye-bye.
Thank you.